Thank you, Mindy. And as Mindy has said, one of the great joys of having an ESC-funded project means that I get to have a team of interdisciplinary colleagues to work with. And I actually want to begin the day by introducing them to you. So throughout the day, you know who the people are who've actually brought us here together. And I'm really, really grateful to all of you. So first we've got Halifom Abraha. He's a postdoc working specifically on data protection on our project. And we've learned that he's won the Dean's Award for that. So welcome, Halifom. We're also joined by Aislinn Kelly-Lyth, who's a researcher in the team focusing in particular on data protection and discrimination law and the ways we can use them to regulate technologies. Aislinn completed her degrees at Cambridge. So Mindy, we have complete diversity when it comes to educational background at Cambridge as well as at Harvard Law School. And her work has been published in many leading field and generalist journals. Very sadly for us, but very excellently for her, she's a Queen's Scholar at Middle Temple and is due to start pupillage at Blackstone Chambers in the autumn. Thank you so much, Aislinn. Our most recent team member is Dr. Six Silberman, who's a postdoc focusing particularly on the technical perspectives when it comes to regulating algorithmic management. Six has a PhD in information and computer science from UC Irvine and has worked as both a software engineer and a trade union official. So in terms of complementary skills, we couldn't hope for anything better. He's also, and this is how I first came across Six, the co-founder together with Lilia Rani of Turkopticon, one of the very first tech solutions to problems arising from digital platform work. So it's really great to have you in the team, Six. We're using multiple Zoom accounts with multiple logins. So what we want to think about over the course of today is really the regulatory responses to the promise and the perils of AI. I think over the past decade, there's been lots of really exciting work done, both from a technical perspective, but also from a legal perspective, thinking about the sort of challenges of bias, of fairness, of accountability and transparency. Now, I think the really important question is increasingly, how can the law respond to that? And it's an urgent question because when you look at what's out there already, can we move to the next slide, please? If you look at what's out there already, there's a quickly growing amount of policy proposals, whether it's here in Europe, whether it's across the world. But rather than focusing on the sort of nitty-gritty of these individual proposals, what we want to do is take a step back. If I can go to the next slide, please. And really, before we do that, what we need to do, can we move to the next slide, please? Before we want to do that, we want to present you with three sort of fundamental questions that we hope will frame our discussions across the day. And those three fundamental questions come out of our work specifically on regulating artificial intelligence in the context of management, in the context of work. But actually, increasingly, as we've been working on these challenges, we're starting to wonder about the extent to which they can actually be generalized across many different fields of regulation. I see colleagues in the room who are working across all sorts of fields, from criminal law to public law. It'll be really interesting to see to what extent some of these themes can generalize. So if we look at the next slide, we see the three questions we've got. Could I have the next slide, please? So the first question is, what is fundamentally novel about these technologies? Because just because we use technology doesn't necessarily change the underlying patterns of what's going on in business. The second question we then want to explore is how far can existing laws take us? Because again, I think it's really important that even if we are facing a novel phenomenon, that does not automatically mean that our existing regulatory apparatus can no longer be applied. But nonetheless, and this then sort of gets us to our third hypothesis for the day, what are the kind of new and specific challenges that arise from AI in the workplace and beyond, and what could be the regulatory responses to that? And that's what we then hope to explore throughout the day, looking both at different jurisdictions, but also looking at very different models of actually regulating AI. We'll have the next slide, please. First question, what's novel? And we have the next slide, please. Here's our hypothesis. We think there are three sort of broad categories along which, when we look at AI at work and possibly beyond, we're looking at a fundamentally novel and distinct phenomenon. First of all, employers have always been collecting data. But we're now looking at a completely different scale in terms of the ubiquity, the constancy and the comprehensiveness of the collection, in terms of the granularity and the intimacy of the information actually collected. So that's the first sort of axis, I think, along which we're looking at a very novel phenomenon. The second thing is what we then do with that information, how we actually act upon last decade have allowed us to essentially do many novel and new things that even in the past, if it had collected all that data, you may well not have been able to do. And there we're thinking, for example, about the inferences you can draw on a vast range of features, that we should also say on a sort of dubious number of features. This is the kind of snake oil AI of having a 30-second video for a job applicant that will then give you perfect personality scores. But I'm told that's more a random number generator than an actual outcome. But nonetheless, I think it's also the fact that you have not just got information and inferences about your current data subjects, but of course also in terms of future communities and future groups. So again, when you think about hiring, you think about there's predictive analytics in that context. And the third hypothesis, and again, this sort of, it's out in the literature and discussed extensively, but really things do go wrong when humans make decisions, but they tend to go randomly wrong. That's a sort of concern, I think, when it comes to AI, is that often we've got patterns in how things start going wrong, and how we can think about the sort of, systemic errors that we're looking at, I think will be a real regulatory challenge. If we look to the next slide, please. I think it's important that we put out our disclaimer at this point. The more you talk about technology, the less it wants to work. Great, well, I'll give you the disclaimer without the slide. The first important disclaimer is just because we have these novel features does not necessarily imply that all our existing regulatory regimes don't work. So in sort of, researching and thinking about different responses, I think we are also always very careful to make it clear that, to what extent can we make existing regimes fit? And so, for example, if you look at the next slide, one of the first sort of major outputs we've got in terms of the project has been work we've been doing with Ruben Binns, who's also here, and Ashlyn, looking at discrimination law and actually thinking along the lines of, can existing categories of discrimination law work? And, other people are in the room as well who've done a lot of work on this, saying, don't give up on the promise of discrimination law just because the source of bias is no longer human, does not mean that our existing rules no longer apply. Nonetheless, if we go to the next slide, we do think there are some fundamentally novel, some fundamentally distinct challenges. And really, when we think about what those novel, as it were, regulatory failures are, sort of market failures that require intervention, require response, we broadly group them into two categories. First, a massive exacerbation of privacy harms and information asymmetries. And second, a real loss of agency. Let me just give you a quick idea of what we mean by those two regulatory harms. Look at the next slide, please. When it comes to thinking about the exacerbation of privacy harms and information asymmetries, really we're looking at a difference in degree that's so stark that it's become a difference in kind. So privacy harms, we think both along an individual dimension, thinking about things like reputational harms, autonomy harms, but also crucially, going back again to those key technical features, we're thinking about privacy harms in a collective dimension as well, in a relational dimension, this idea that actually, I can do stuff with my data and Halfon's data and Ashlyn's data much more than just to the individuals involved. And these sort of relational harms, I think, are a really important regulatory challenge because they're arguably one of the least regulated or sort of least captured by our current legal structures. But it's not just that. It's also the massive information asymmetries we have, both in terms of gathering information and what we can do with that. And it's really interesting that whether it's through inferences, whether it's through tacit knowledge extraction, in principle, from a labor economics perspective, having lots of information isn't a problem. Labor markets have always been marred by information asymmetries. The real challenge is what we then do with that information. And what we see at work, but I think also beyond, is that that information is not necessarily used to increase overall utility, but actually to increase power and control in particular relationships, whether it's in employment or beyond. And those are the sort of harms we then think about. Harms, for example, when it comes to bargaining, harms when it comes to predicting how much a wage an individual worker will be willing to take, and therefore also weakening the collective aspects. But the same sort of stories applies to, say, bargaining with consumers in various online forums. The second challenge, if we look at the next slide, please, relates to this loss of agency, both through the automation of functions that humans traditionally exercised, but crucially also, even if we're not fully automating it, through the augmentation with various tools of traditional functions, whether in the employment context, it's hiring, all the way through to firing workers, but lots of other elements as well. And our real concern here is, in a sense, a loss of agency of the human involved. In the employment context, think of it as a loss of managerial agency. This is when you get to the scenario where a major warehouse operator in the United States gets sued for sacking trade unionists. And the legal response is to say, local management of this plant neither understands nor has any control over the software that actually terminates the workers in that warehouse. That is what we mean by real lack of agency. And of course, that leads to problems both sort of, metaphysically, when you want to think about questions of dignity, of the right to actually engage with humans, but also very practically in terms of, having some flexibility, having some, just interaction with a human manager. For our purposes, this loss of agency is particularly interesting because our hypothesis is that a loss of agency tries to condition the exercise of that human agency, both ex ante and ex post facto. And so the moment we no longer have this clear agency within the sort of larger corporate or various other organized structures, it becomes really difficult for legal responsibility to find a way of accurately ascribing responsibility. And so I think one of the big challenges, and I hope one of the big sort of discussions and themes we can have throughout the day today, is to what extent can we restore that kind of agency, or what do we need to do to restore that agency in order for regulatory systems to work? And we go to the next slide. I think that's it from me for now. Thank you so much for joining us. I'm really looking forward to our discussions, and I hope you have a great day.
So good morning, everyone, and thanks to the organizing committee for inviting me to Oxford to speak in this important conference. I'm going to speak about data protection as a tool to regulate artificial intelligence, and my focus is going to be on the African perspective. Next slide, please. So in order to appreciate whether the ability of the African data privacy law, whether to regulate artificial intelligence, it is important in the first place to understand the landscape of data protection in the continent. Now I have provided a map which provides some minimum information about data protection in Africa. It's not a very current, it's not so much a current map, but it shows that up to the present, we have 30, it shows 43 African jurisdictions with data privacy laws, but we have an addition of Eswatini. So it has recently enacted a data protection legislation. So we have 34 out of 55 African jurisdictions. The other important thing that we need to understand with regard to the data protection landscape in Africa is that studies have established, and in this case, I'm very much precise, with the survey by Professor Dunleaf Graham, which has indicated that the African data protection regulations depict or rather exhibit very strong similarities with the European data protection regimes. So it is comprehensive as the GDPR is, and it has the minimum information processing principles, and it has a centralized institution, normally called the Privacy Commission or sometimes data protection authorities. So that it is, but when we further analyze the data protection landscape in Africa, we see three categories of levels of implementation of the law. We see the first group comprised of the countries which have in place the data protection legislation, but they have not yet brought such laws into force. And probably this is because these are recent enactments. And I have to make an exception of the Seychelles, which has got a data protection legislation since 2003, and it has not come into effect. I don't know why that has been the case. And the second group of these countries comprises those countries which have brought their data protection legislation into effect, but they have not yet appointed the data protection authorities. So in theory, it is very impractical to enforce such kind of laws. And the last group is those jurisdictions which have brought the legislation into effect, and at the same time, they have appointed the data protection authorities. So when we closely look into this pattern, one might conclude that we see there is a growing rise of data protection legislation in Africa. But when it comes to enforcement, it's really a big challenge, because right now we have a very low enforcement of such policies. And again, when we try to look into this data protection landscape in Africa, we see that at the continental level, there is a very little effect of the framework at the African Union level in terms of law reform in Africa, and also the question of harmonization of data protection policies. So right now we have the African Union Convention on Cybersecurity and Data Protection. This one was adopted in 2014, and it has not come into effect up to this point for want of 15 ratifications. So I was just checking the African Union website last night, and it shows like only 13 African jurisdictions have adopted such have ratified such a convention. So we still have more ratifications to go to make this convention into effect. And the interesting part of this convention is that currently the African Union has initiated a revision process of this convention before it has even taken. There is a call for consultants to work on this project. So that is briefly what I can say about the pattern of data privacy landscape in Africa. Next. Now, when we look into the artificial intelligence diffusion is currently growing applications of artificial intelligence technology. And the most important key sectors are agriculture. We have the application into education sector, financial services, and we also have the application of artificial intelligence technology in the health sector. So these are the main application of artificial intelligence technology. But when we try to look generally into the diffusion of technology in Africa, we see that Africa is still facing the challenges of digital divide, but we also have problems relating to data gates. We all know that artificial intelligence so much accurate, how it is being generated, the quality of the data, and so on and so forth. Perhaps it's because of this that the African Union saw it very important that it should make an intervention. And in this case, the African Union adopted the African Union's digital transformation strategy for Africa as a blueprint for the diffusion of technology into Africa. And we see that 17 education, research, and training. We also see some initiatives to support education startups. So this is when we can view Africa in terms of now, when we look into the regulation, I've just provided an illustration from the Ugandan Data Protection Act of 2019. So we don't have very specific laws which have been put in place in order to regulate artificial intelligence, but rather we are working around the existing laws. And this provision is quite similar to other African laws, and it's about automated decision-making processes. And the default rule here is that the law prohibits data controllers to make automated decision-making, which significantly affects the data subjects. So this is a general provision, but when the data controller decides to make such kind of decision, there is a requirement of notification to the data subject, and of course the data subject is given a chance to make a request for reconsideration of such a kind of decision. And there is now a general exception that in the context of contractual arrangements, and specifically in the employment sector, the data controller may make such kind of automated decision making without notification to the data subject. So that is the first exception. But the second exception is where there is an authorization from another written law. So in those kind of situations, it is possible for the data controller to take automated data subject. Now, what are the central issues that come out of this setup of African data protection regulation in the context of artificial intelligence? So, as I mentioned in the first slide, is like, I mean, the second slide is like, next slide, please. So we see that there is a relatively low uptake of artificial intelligence in Africa. And of course, this has a big implication in terms of comprehension of the risks that are coming from artificial intelligence itself, and how the policymakers and those legislators and the academics may come in a policy discussion. And when you combine this with the general law literacy level within the continent, matters become worse, because when you have, for example, an individual against whom automated decision has been made based on the artificial intelligence, it is very challenging for him or her to know how to go around to go about such risks. But we also see, as I mentioned in the beginning, that we have national artificial intelligence strategies in almost 17 African jurisdictions up to present, but these have not yet been resulted into any concrete regulation, and probably it's because there is no much policy discussion, strong policy discussion in Africa on how to regulate artificial intelligence in the field of data protection. The most important question when I think we consider about regulation around the artificial intelligence would be the issue of transparency and accountability. I've just mentioned about the automated decision-making process, and we see, for example, the general law prohibits data controllers from taking up such kind of decision which have significant effect on data subjects. But the only thing this data controller may do in that case, he has an obligation to notify the data subject. What if such a data controller, for some reason, decide not to notify the data subject? What will happen? So it is a matter of transparency that a data subject should be in a position to know whether such a kind of decision has been made, and it should be in a position to challenge that in any case. So I think when we are trying to consider issues relating to regulation of artificial intelligence in the field of data protection, the mechanisms of transparency and the accountability are quite important, at least at the minimum. Of course, when we look into most of these legislation in Africa, we may find some of these mechanisms relating to transparency and accountability. But the problem is we have followed the first presentation from Jeremy, that the magnitude and the risks that are coming from artificial intelligence are sometimes quite new. So how can we increase the level of transparency, and how can we increase the level of accountability on the part of data controllers? These are quite important issues for consideration. And as I mentioned in the beginning, we have another challenge in Africa relating to harmonization of data privacy policies. So this is a very big problem. We see that there is a very strong influence from Europe. So every country in Africa is trying to follow the European model, and of course the discussion which are taking place in Europe, those are quite important for Africa when we are trying to consider the regulation of artificial intelligence in the field of data protection. I also mentioned about the Convention on Cybersecurity and Data Protection, which has yet to come into effect, and this, of course, could have some impact on the entire spectrum of data protection regulation in Africa, but it has got no such effect at the moment. So finally, what I may conclude here is that issues of regulation of artificial intelligence, they are quite complex issues, and we don't have a straightforward response on how the law should regulate artificial intelligence. And it's quite important that we continue getting into policy discussion at the global, regional, and the national levels, and try to learn from others. What have they put in place? How has that worked out? How can we learn from others at the same time trying to take into account our own situation in the context? So that makes the end of my presentation. Thank you for your attention.
Links permitting, we're now joined by Elizabeth Benham.
Thank you very much, and good morning, everyone. When I'm presenting, I may be looking at my notes a little bit more often than usual because it's 1:30 in the morning in British Columbia, where I am right now. But I'm very sorry that I can't be with you in person and to meet with my colleagues gathering in London. So my perspective and my contribution to this panel is the view of a data protection regulator. And I've served as a data protection or a privacy regulator for almost 20 years in 4 jurisdictions, including most recently as the Information Commissioner for the UK. But in addition to that perspective, I also want to add my most recent experience, and that is as an advisor or consultant to clients of a global law firm, Baker McKenzie, and I'm specifically advising clients on the development and the implementation of data ethics programs, which are mainly focused on AI and machine learning. So I've been around the regulatory world long enough to have seen profound changes in the challenges of data protection regulation. And I've also seen privacy come of age. In the early 2000s, in my first job, the files on my desk were still paper-based data breaches and fairly simple analysis of information systems. By 2006, new technologies and new business models were emerging, and I was Assistant Privacy Commissioner of Canada at the time, where I led an investigation of Facebook and its app platform. And in 2008, most people did not understand the implications of advanced analytics, app platforms, and tracking and profiling by social media companies. I think it would be a stretch to get somebody to really understand even what an app was. But then, as Privacy Commissioner of British Columbia in 2012, we investigated the Vancouver Police Force use of facial recognition technology during the Stanley Cup riots in that city and found it illegal. Fast forward to 2018, when the GDPR took effect across the EU, and that law, you know, as we have just heard from my colleague, that law has encouraged and inspired new laws and law reform around the world. And I think the combination of that new comprehensive data protection law and also the data scandal that was Cambridge Analytica and Facebook made data protection dinner time conversation, certainly in the UK, but I would say Europe and around the world. And the Information Commissioner's Office, my office in investigation, was considered leading edge at the time because we did a forensic analysis, an examination of 700 terabytes of data and the algorithms allegedly used to micro-target voters in campaigns in the US and in the UK. Now, the ICO published policy and enforcement reports, and those reports really pulled back the curtain on tools in use across a wide swath of organizations involved in data-driven political campaigning. And I bring this example to your attention because it was one of the first data protection investigations that applied the law and the enforceable principles of transparency, fairness, and accountability to the use of data analytics in the context of something that deeply mattered to our society, and that's free and fair elections. We found multiple breaches of the law, and we took enforcement action against numerous organizations that were involved in political campaigns, political parties, data brokers, social media platforms, and data analytic companies. And the ICO also successfully tackled the use of live facial recognition technology by police and determined the governance, guardrails, and the threshold that needed to be reached before police could legally use the technology. And data protection authorities are we're not in the business of banning a technology. but rather to circumscribe the context in which it can be used. So that gives you a little bit of perspective about how data protection regulators are starting to apply the law to advanced analytics and artificial intelligence. But is data protection law sufficient to effectively protect people while still facilitating the development of AI that works for society? So we all know that no law at present regulates AI in all of its applications. And everyone in this room knows that AI is a very broad field that encompasses a whole spectrum of solutions, from the relatively mundane, like spam email filters, to the more innovative and complex, such as advanced robotics, consumer preference algorithms, and recruitment software. Data protection law is, maybe I'll stop there and just check on whether the sound is working. Can someone signal or tell me in the message if you can hear me?
It's great, Elizabeth.
You can hear? Good.
Yes.
Okay, thank you. So I think data protection law is a good basis for AI and analytics, which use personal data and which affect consumers and citizens. Some of the principles in data protection law, fairness, accountability, and transparency, and laws like the GDPR that require explainability. Sorry, I'm just getting some interference.
One, two. Nothing. It's just, we're getting. Now we're not even getting.
Can someone let me know if you want me to start again? Because I just hear a lot of background noise. Okay, I'm going to push on. So some of the principles in data protection law, fairness, and accountability and transparency, and laws like the GDPR that require explainability and give individuals rights to challenge decisions that are made by machines, take us some way to provide oversight of high impact AI systems. But the GDPR provisions that give data subjects the right of explainability and the right to challenge are very narrowly scoped, and they only encompass significant decisions that are made solely by machines. And in most AI, at least now, there's usually a human in the loop somewhere. And so the actual rights for individuals and the redress are very, very narrowly scoped. One area of the GDPR that's underexplored and could be used to clarify the law and give assurance to AI developers is codes and certification. And I think it's disappointing that we have yet to see a GDPR code of conduct that's developed for AI in a specific context, like health research or policing, for instance. And I think that ultimately, the way that we use AI needs to be context specific and developed for the systems with the highest impact and the highest risk. And that's the model of the EU's AI regulation at present. We also, though, I think, need certification and third-party agents to do the work that's backstopped by a regulator. But even if we take into account parts of the law that are underexplored, my main conclusion is that data protection law is not enough. Data protection law doesn't deal with societal harms and making the right decisions. Data protection law contains obligations for organizations to assess privacy impacts, and in some cases to be required to show their homework, but it doesn't compel or ensure that the right decision is made. And just to give you an example that I think is really familiar to those that are in the UK, and that's the A-level algorithm that Ofqual in the UK implemented to determine A-level exam marks during the pandemic. So when students weren't able to sit their exams. When the ICO looked at that algorithm, we found that it did not contravene data protection law, but it was obvious that the algorithm had a negative societal impact because it downgraded students from state schools in disadvantaged areas of the country. And it didn't take account of smaller classrooms and other impacts of more prestigious schools in wealthier areas. So the societal impact is usually, not always, but usually out of reach of privacy regulators. And that's why I think we see policymakers around the world really grappling with AI regulation. So the AI proposed law in the EU, we just saw 2 weeks ago another proposed law in Canada. We've seen it elsewhere. The UK government is also signaling a white paper that will be tabled in the autumn on AI regulation. We know that there's work underway at the OECD, and there are discussions between Brussels and the US over principles under which AI could operate and what the legal limits should be. Now, if there could be some agreement there, I think it would be a major win for transatlantic digital rulemaking. The backdrop here is that for businesses and for society, personal data is more important than ever before. Data analytics and AI are embedded in so many different aspects of a business. It can refer to robotics, machine learning, and a whole range of other technologies that simulate human intelligence. And of course, innovation is core to success, but so is public trust, and so are the needs of customers and consumers and citizens. In my work advising progressive companies, I see a move to data ethics, and these initiatives reach beyond the existing law. And I think the incentive to go beyond legal compliance is companies' reputation and trust. So I think leading companies know that customers and boards and investors and partners and society expect more than basic compliance. And many global companies, especially in financial services, HR recruitment, health and life sciences, are turning to data ethics because they want to ensure that their use of AI and advanced analytics is sustainable. And I'm really excited by, and I'm really encouraged by these initiatives and by companies that are establishing data ethics review boards that include independent members. Legal and regulatory approaches will be all about data governance and the need to establish regulatory requirements to ensure that organizations are doing the work they need to do to assess the impact of their use of advanced analytics, the impact on individuals and on society as a whole, and stand ready to demonstrate them. Algorithmic auditing tools and explainability standards are really key, both of which the ICO has developed in partnership with the Alan Turing Institute and with the help of citizen juries. Data ethics and data ethics review boards will be a tool. Technical standards are an important tool. And I'm somewhat optimistic about the future, but we need policymakers and regulators and companies and governments to really double down and work with academic researchers to prioritize this work to ensure that AI works for society. And that's a journey. So I'm going to leave my remarks there, and I look forward to hearing from my fellow panelists and discussions with all of you in the room. Thank you very much.
I cannot hear, but should I be the next speaker? Okay, thank you, Elizabeth. So it's been really an honor to speak here and share the stories and what's happening in China when we develop and use AI in many scenarios. So I would like to share some of the stories happened in China. The first one is related to the combination of hard law and soft law, which I think is a great example when we don't have the data protection law and how the society could get benefit from the soft law. And what about when we have it? So actually, it's like 3 years ago when facial recognition was on in many classrooms in China. The purpose is to recognize who is not, focused in the classroom, and who has gone to sleep. So that's one of the most horrible design that I've ever heard, and also that I've ever seen for on AI for next generation. There are many reasons to have negative comment on that, but I think in the interest of time, we're not going for that part. So the problem would be that, okay, now approximately 100% of the general audience have very negative comments on this kind of trying in the classroom in China 3 years ago. So people don't like it. But at that time, there are no law who says that in China who says that you cannot use facial recognition and emotion recognition in the classroom. But people don't like it. So at that time, the Ministry of Education jumped up saying that, first, the general audience don't like it. Second, we need to have proportionality of AI in the society. That means you cannot use AI everywhere. It has to be used appropriately in some of the scenarios. You know that the Chinese government, when they have a nice talk with you or having a nice Chinese tea with you, that means a lot to those Chinese companies, although they're not against any Chinese law at that time. So it was stopped everywhere, although it's not a hard law. So, so actually later, when I shared the story in other countries, my colleagues from other countries was like, "This will never gonna happen in the United States, because when you don't really have a law, you say that, and then you talk to Meta or Microsoft, and then if they have similar tryings, they could say, so in which degree that I'm against the current, the US law. If not, who cares?" I'm not sure whether this is true, because this is a comment from my colleague somewhere else. But I would like to compare the patterns in here, that the soft law, in some cases, it also helps. Well, at least 3 years ago, when we don't have the personal information protection law released last year, it also helped us. So I think data protection law is, of course, very essential for the society, but we also should see how the governance network is taking an effective role in different ways, not only for the hard law, but also for these soft laws, and the role of the reactions from the general audience on how they can help to shape the laws. I think one of the reasons that we released the personal information protection law in China last year is because of this kind of practices, negative practices happened periodically in China. So then the general audience is pushing the government to take actions in a much quicker way. My second story that I would like to share is related to the part that the challenges for grounding data protection laws. Last year, what I said, you can search on the Google search engine if you're interested in the Chinese trying on the personal information protection law. But what I would like to say is that although for those countries like China, like Europe, and for those more than 30 countries in Africa that my colleague told about just now, we still have many, many technical challenges to take things grounded into realities. One of the examples I would like to share in here is that now you have many facial recognitions. If you're logged in for your bank account on your mobile, and then they would like to require your facial identity to provide you with services. At least in China, we do that. And you can see a circle actually circulating your face. And then you put your face into the circle. For some of the, for some of the people, they're kind of naked for their upper side of their body when they're using this kind of facial recognition software, because they assume that when you're having a circle, you do not need the extra information from us. So what's really happening is that for those service providers, they do not only steal the information about your face, they also take the whole picture of your upper side of your body in many cases. And when people get to know that, they were like, very, very angry about this. So they were like, you never told us that you need the information from our upper side of our body. And then I was surprised that some of the practitioners jump out to say, because we need to identify whether you are real life people. And then because we need those information. Of course, you can need these information to provide services, but how can you, not to tell other people about the extra information that you're taking outside the circle that you're requiring. So you see that although this is, with consent of acquiring the information, but they're acquiring more information than they described. So they're not saying they don't do informed consent. They do, but they don't tell you all the information. That's something we have to, be very careful about as general audience and as scientists in the field of AI. The second challenge I would like to raise is for data erasure. Data erasure was written in not only in the Chinese personal information protection law, but also in GDPR and in many other places. I assume that it's everywhere in data protection, in different versions of data protection laws. But data erasure looks very, great. When people, don't agree with you, they can withdraw their data. And then for those giant companies, they say, of course, we provide this kind of services. We will delete your data. We will not use your data anymore. But what's really happening for those AI companies is that they delete your data from their databases, but they will never delete your data from the artificial intelligence models where they use the data to train their machine learning models. Well, the reason was because when you request the data erasure from the system, you're expecting that in the next second, they delete your data. But the real case is that in artificial intelligence models, there's no way to delete concrete data from the models right now. The only way that the companies withdraw the data is to retrain the artificial intelligence models. And how long they would like to retrain the model? Maybe 2 weeks later, maybe a month later, and maybe half a year a time. So this is what's really happening. That within the database, they do not have your data, but within their artificial intelligence models, your data is still there. And I'm 100% sure that for current AI model, there are ways to retrieve your data from the machine learning model. That means your data are still there. But for those AI companies, they never tell you about this. Well, this because I'm an AI scientist myself, so I know that the tricks right there. So you can ask all the AI companies in which way you're deleting my data from your AI models. You will never get reply. This is the current challenge, that although we have the data protection law everywhere and it looks nice, but when it comes to details about how to implement them, I would like to say in many cases, the industry are cheating us. So this is why we need to stand up for ourselves. I think in a strategic way that the academia and the general public and the governments has to make the efforts together to push the industry and also the academia to take actions on how really we have to, take these principles and laws into reality in a technical, plausible way. I'll stop here. Thank you. Thank you.
My job is to bring all of this together and to try and draw out some common themes. Where I think my main issue will be making sense of the scribbled notes that I have rather than technological. But I think based on what the three speakers have said, I'm going to maybe pose two questions that will hopefully spur some discussion. So the first is the data protection framework appropriate? And then is it because we've heard from various speakers that we should be wary simply because there is a data protection law on the books. This might not necessarily mean that it's applied, and it might not necessarily mean, as I'll talk about a little bit more, that it's a rights-based framework. And then I think the next question is, how should the law deal with this kind of knotty relationship at times between law and innovation, and regulation and innovation? And if I have time, maybe I'll say a little bit about potential for international convergence here. So just to kind of recap, I guess, we're talking here about the role of data protection frameworks in regulating AI. And these data protection frameworks, when you strip them back to their essentials, what we have is a system of checks and balances that applies to personal data processing. And then that has a core set of principles that apply to that personal data processing, where you need a legal basis, you need compliance with certain data governance principles. And then data protection frameworks, we see kind of additional layers tacked on to that kind of core model, and this kind of meta-regulatory framework where principles like accountability are introduced, and requirements like data protection impact assessments and the codes of conduct that Liz Denham mentioned. So how can those frameworks regulate AI? Well, when you look at this globally, I think very few frameworks have specific provisions dealing with automation and profiling. So, the earlier generations of European data protection law had provisions on profiling, but they were in fact effectively dormant provisions. That there is a specific prohibition or a right not to be subject to automated decision making, we see that in some ways it's heavily caveated. So you have that decision making has to have a legal effect or a similarly significant effect on a person. It has to be wholly automated. There are exceptions there for consent or in contractual situations, or where simply a state legislates to allow for something like facial recognition technology. So we could query then whether data protection in that context is going to offer. However, I think the more fundamental query is whether or not a system, a legal framework that was designed in the 1970s as a way to kind of deal with data banks and databases and individual kind of dossiers is suitable to tackle the challenges that we see now, and in particular the fundamental rights harms stemming from AI. And here, the bulk of the discussion has kind of focused, as Liz Denham mentioned, on this question of whether or not the data protection framework is too individual-centric. Does it focus too much on individual rights and omit the kind of collective or societal harms that stem from personal data processing? And again here, why might we say that? Well, a lot of the debate kind of goes back to personal data processing. And we know that personal data is defined as information that relates to identified or identifiable individuals. Now that's the definition in the EU framework, but also the Council of Europe Convention 108 framework, in the Chinese Personal Information Protection Law, in the African Union Convention. So there's actually quite a lot of global consensus around that definition of personal data. So it's really fun, this identified individual. Because as Jeremias mentioned at the outset, in an automation context, then profile or to glean inferences about others. And so can data protection law kind of deal with those kind of indirect? I think it can, because the definition has been interpreted by the Court of Justice of the EU, at least in the EU context, in a purposive way. The aim of data protection law is not to protect data, but to protect people from the harms of data-driven decision-making. And so as academics or civil society actors, it really makes no sense for us to kind of argue against this perspective. Yet, even if we say that the concept of personal data can account for these kind of indirect data relations, still we see that the system might have some limitations and some flaws, as Liz Denham mentioned. So one example here might be that I consent to automated decision making about me, and yet that has implications for Alex or others, and therefore well, here I think data protection law becomes most relevant when you strip it back to its essentials. And these are these core principles that you find across data protection frameworks globally, including OECD principles and APEC privacy principles, et cetera, So these principles of things like data minimization, purpose limitation, fair data processing, and these to date have had a relatively limited run before courts and others. However, the Future of Privacy Forum, a think tank on privacy, recently published in April of this year a report on the use of data protection in the context of automated decision making. And they showed that it was actually these principles and the requirement for a legal basis that were having most effect in terms of restraining and constraining the impact of automated decision making in certain contexts. So just maybe to give one example, amongst those principles is a principle of fairness. And this isn't kind of tied to the fairness of any individual's data process. So again, Liz Denham gave the example of the Ofqual algorithm used to calculate A-level results in the UK. and said that in the UK, the regulator had concluded that that there was no kind of data protection case to answer in those circumstances. Well, the FPF report provides examples of where data protection law, and in particular the principle of fairness, was used to deal with a very similar issue of predictive grades that failed to account for the individual circumstances of those who were taking exams in a way that was discriminatory, but also just simply failed to take into account individual circumstances. So failed to see individuals for their personal qualities, their personal performance, their background. And I think it was the Norwegian DPA, or Data Protection Authority in that instance, in fact, and a predictive system by the International Baccalaureate team was in fact contrary to data protection principles. So this, I think, brings us to a really important point, which is across the globe, and I think Alex's presentation showed this really nicely, we can have data protection. Are they actually being applied on the ground by data protection authorities? And this is an issue everywhere, I would say. But two, what's the ethos that is underpinning those data protection frameworks? And here I think we see, and I think we'll see it even further into the future, clear water emerging between data protection frameworks that have an economic logic that underpin them, like the APEC privacy framework, the ASEAN privacy framework, probably the OECD privacy framework, and those that have a more fundamental rights underpinning, like the Council of Europe, GDPR, the African Union Convention, if implemented. And why is that important? Well, because when you're applying the principles of data protection law, there's actually, one of their advantages is that they're quite flexible. So there's quite a lot of leeway in terms of how you interpret them. And a lot of them are purpose driven. So something like data minimization. You collect the minimum amount of data necessary for your purposes. Well, looking at this from a fundamental rights framework, you might say that the data processing entails a breach of fundamental rights. We interpret fundamental rights in breaches of fundamental rights need to be justified, and there's a strict interpretation there. And therefore, we might have a strict requirement of necessity. So you can only collect this data, for instance, if it's the least restrictive way possible of achieving your aims. Or we could interpret necessity as this is convenient, this is efficient, or this is one of many ways in which we could achieve this aim. And so there, depending on whether or not you approach this from a fundamental rights perspective, I think the outcomes the law can achieve will be entirely different. This, I think, could be incredibly problematic for the UK going into the future, in particular, if we see proposed changes to the Human Rights Act. Okay, beyond that, I think we have this question of the relationship between the law and innovation that was raised by several of the speakers. So Professor Zhang, for instance, mentioned the difficulty of applying certain rights that we have on the books. He gave the example of the right to delete to new technological contexts. And so here we're in our classic kind of scenario of where a technology develops faster than the law, although I'm looking at a sticker at the moment that says breaking the law is not innovative. Yeah. And so you might say where a technology develops in breach of the law. And here I think we could insist on rights respecting innovation. And I think even the Court of Justice here has really muddied the water in some of its case law, where it said that data controllers under data protection law need to respect the law to the extent possible within their powers, capabilities, and responsibilities. Well, if I design a system where it's not within my power to satisfy data subject rights, does that mean I get away scot-free with a breach of data? Similarly, we need to question what constitutes innovation. The late David Graeber had a great book on this about jobs, and we might query whether we could say the same thing about innovation. What constitutes innovation in a given circumstance? And how is innovation taken into account by in data protection frameworks? Again, here, if I look at the UK, a worrying proposal is that the ICO will need to explicitly take into account the impact of its decisions on innovation in applying the law. Again, this really takes us away from a rights-based framework where, you know, we might kind of equally balance rights and innovation. Whereas, you know, any understanding of rights would say rights are trumps, and therefore limitations on rights should be limited to what is strictly necessary. Finally, then maybe, how then in this kind of international context do we achieve a kind of a rights-based vision of data protection that could play a small part in here, one advantage of data protection law is that it is already on the books, even if not applied in many states. And so again, Professor Zheng kind of illustrated that other soft law mechanisms can be useful while you're waiting for data protections or other laws to arrive. But if you want something immediate, data protection law is on the books in, I think, over 130 countries worldwide now. And in that context, the Global Privacy Assembly has kind of pushed for this kind of more human rights-based vision of data protection. And for countries where, for instance, there is no existing right to privacy, but there is a data privacy law, then they've kind of encouraged coalescence around Convention 108 of the Council of Europe, where, for instance, you have some South American states already signed up, you already have 5 African states signed up, and where it's a principles-based and a flexible framework that is open to all signatories. And that to me seems like a more realistic kind of pathway than something like the UN kind of stepping in at this point, where in fact its track record so far in the area of privacy has been quite weak. No broader treaty framework for privacy and data protection. So there are, I think, some of the points, obviously not comprehensive, but hopefully enough to start a discussion.
Thank you, Ola. Thank you very much for the excellent summary. So I will ask one overarching question and we will open the floor for the discussion. Ola and Elizabeth have mentioned that data protection is not sufficient to deal with societal harms. But one thing that most of the AI strategies coming out now, they directly speak to the fundamental principles of data protection, whether it's fairness, accountability, and transparency. So in that case, anyone, if you can start. I hope the speakers online can hear me. Anyone can you start? Yeah.
Yeah, thank you very much for your question. In my view, I think the existing principles like fairness, like data minimization, accountability, these should be taken as the starting point for further discussion and consideration on how to regulate the artificial intelligence. And the issue is that we see that the artificial intelligence has come with so many challenges that go beyond what we knew before, and practically that makes it is very difficult to bring the same within the existing framework. So I think it is quite important to see how we can enhance, because we may have the as the discussant has mentioned, but we should take that as our starting point on how to increase, to enhance those principles in relation to the harm and the challenges that are coming from the artificial intelligence.
Thank you. Ola, do you have?
Yeah, I would agree. So I meant to emphasize that, you know, both professors have kind of said transparency, accountability are kind of key. And they are existing in the law. I think some of the challenges come from, again, Lieutenant mentioned remedies, for instance. In the EU, we have kind of the right to representative actions, kind of stumbling along, but still making its way forward and is on the books. The issue will be that type of representative action isn't possible in every state. But also, I think if you look at something like the Siri judgment that we saw in the Netherlands, there the court, in looking at automated decision making, anchored its reasoning in the right to privacy, so kind of bypassing a lot of this discussion about is the data personal data or not, et cetera, so there's an impact on privacy, but then invoked these kind of Article 5 data protection principles in order to show that the interference with privacy was disproportionate. And so in that sense, again, data protection kind of gives you a big nudge or normative nudge in one direction, even when applying something like the right to respect for private life. So I don't think we should kind of underestimate the role of data protection. It's just, it might not, for instance, get you to bans on certain technologies in certain instances, largely because of the way it's applied.
Thank you, Ella. Elizabeth or Yi, do you have anything to say?
If I can come in, I'm not sure if people can hear me or not. Can somebody in the room signal if you can hear me?
Yes, we can hear you.
Okay. I think that, as I said in my opening remarks, that data protection principles get us some way towards, I guess, taming AI and making it fit for society. It goes some way, and it's also, we have jurisprudence that we can rely on. I think the laws, as Orla said, that are based in fundamental or human rights give us a step forward. So that's good. That said, there are many tools in the law that are underexplored or unexplored. And I mentioned codes of conduct, and I really want to emphasize that codes and certification systems could be very, very helpful here. And the other point is that data protection regulators have not done deep dives into fairness. So there aren't that many decisions in data protection, and Orla, you may think of some, where there's been jurisprudence on fairness. And I think that would be helpful. I think also of data accuracy and data integrity, that those provisions in the law might help us as well.
Maybe I would like to add two perspectives. One is that, well, just now we also mentioned transparency. I think something interesting is that when we develop the technology and when we have the laws, so in many cases, when you are creating the hard law and soft law, some of the statements are socially very needed, I would say, but technically very impossible. And we have to be very careful about some of these points. Like, we wanted the AI models or big data analytics to be transparent. So people write AI must be transparent. But in most cases, almost in all cases, for the current widely used AI models, they're not transparent. They're technically not possible to be 100% transparent. So I think some ideal way as a hope to be included into both soft and hard laws will be very problematic. Otherwise, you should stop use AI because none of them are transparent now. And also, I would like to raise a concern that when we have good data, relatively complete data, it does not mean AI models then is safe enough to provide us good services, because there are many uncertainties in real world scenarios. On the other side, that means when we have the when we have the data, the good data, we also need to improve the AI models so that there are robustness to provide better services. Thank you.
And I'm interested in what you were saying, Ola, about the potential problems if human rights law is downgraded and if free speech is given some particular priority over privacy. Do you think data protection law has enough internal protections for privacy, perhaps in the fairness principle, but would that good?
Thank you, Mike. Mike, here. Yeah, exactly.
From UCL. We see in some areas like ad tech, where the entire kind of the political economy of analytics is organized in a way that is quite troubling to deal with in data. Very hard for them, as Ola said, to be identified as having the responsibilities, powers, and capabilities to fix a system. It's almost a kind of decentralized setting. And we also see that emerging in machine learning quite a lot. We see AI being moved through many, many models, many layers of models, general purpose systems embedded in other software. We see the work from Seda Gurses, for example, on agile development and how software systems are becoming quite slippery to regulate. And I suppose my question then is data protection, and also the way data protection is dealt with through data protection regulators, up for the task of really tackling some of those issues which are about the structure of industries a lot more. Whereas we've seen in other industries, they've been tasked to regulate, like ad tech, that have similar characteristics, that they've had rings run around them.
One more question and we'll proceed with the discussion.
Thank you so much. Carly Kind from the Ada Lovelace Institute. Ola, I have a couple of questions for you. One is that you were talking about the definition of personal data in data protection. And we've been working quite a lot on biometrics data, as you probably know. And one of the interesting challenges there is that biometric technology for categorization tends to deal with data that doesn't fit the definition of personal data if it's not primarily in the workplace or in recruitment systems. And I just wondered how you thought about and whether we need an expanded definition of personal data that brings in those types of characteristics, or whether you'd say that already is permissible within the data protection framework, which I think is what the ICO says. Sorry, quite a technical question. And then a slightly broader one, which is on this innovation grapple with questions of actually the efficacy of technology and whether or not a technology works and does what it says it does, and therefore whether it's necessary and proportionate. In particular, I'm thinking about things like, for example, contact tracing apps, where there were lots of bogus claims being made about how those technologies could reach a range of different, quite legitimate, you know, if they worked, they fit within a proportionality assessment, but they didn't work, or they didn't do what they were being said that they would do. So how can the framework better require a demonstration of efficacy of technology or some type of validity of technical claims being made when thinking about rights infringements?
Should we address these questions first? Anyone can start?
Yeah, sure. So if I start with the first question by Helen Mainfield, to what extent can the human rights dimension of data protection be downplayed within a framework? I think it can be quite extensively downplayed. So, you know, if we take an early example from the UK of the personal data has to relate to somebody, and you know, an expansive human rights approach would say it relates to somebody because it impacts on them, or it has the potential to have a negative effect on them or influence them. However, early Court of Appeal case law in the UK said it impacts on somebody, or it consents. So essentially it's private. So you can see there you've got this kind of same definition, whether or not you have a human rights spin on it or a non-human rights spin can drastically change the way the law applies. And I guess my worry is that once you remove, or if you remove underpinning fundamental rights by, for example, effectively gutting the Human Rights Act, then that kind of ethos and the interpretation of the principles will render a lot of things like purpose limitation, data minimization, etc. Instead, put rights on a par with economic and other interests. So I think that's a huge concern. Maybe then, if I don't know, do you want to add anything?
Yeah, maybe I have very little to contribute on this first aspect of human rights, because have a very concrete jurisprudence on human rights with respect to data privacy in Africa. And to my understanding up to this point, such kind of rights. So we normally think that on human rights. So that is the starting point, and we should continue to look into data protection from that lens, or from that angle, that the fundamental human rights should be taken on board when we are trying the principles under data protection frameworks.
We have questions from Michael. Do you want to address the structural problems?
Yeah, absolutely. I mean, going to the point that data protection might not be able to kind of address very complex data processing frameworks where responsibility is kind of obscured by the way in which the setup is designed. I think for me, there could be two, but first of all, there's a frustration when data protection authorities deal with very discrete aspects of this framework. Have to look at certain relationships between data controllers and data processors, and a very technical approach is taken to this. I don't think that's necessarily required by the law. And I think I say that for two reasons. First of all, data protection authorities do have the power to initiate kind of ex officio investigations when used in a kind of a legitimate way, rather than to undermine the rights of complainants. And in that sense, they can investigate an entire industry. And if they find failings across the industry, it is within their responsibility to kind of deal with those issues. In the EU context, for instance, one question I would have is the extent to which a data protection authority might, for instance, in some ways appeal to higher norms, like the EU Charter of Fundamental Rights, to simply say this entire system is a violation of fundamental rights. You apply, for instance, the logic of case law from the European Court of Justice, where you see kind of data processing at scale that involves particularly sensitive personal data processing. That's looked at as prima facie a significant interference with fundamental rights, which can only be justified in the kind of most significant circumstances, and in some cases can't even be justified. Well, how do you apply that logic to something like ad tech? I would say that prima facie, this makes it incompatible with the Charter, but we've seen regulatory authorities very reluctant to appeal to those kind of higher level norms, instead kind of preferring to kind of stick to the kind of nuts and bolts of the data protection framework. But I think it's within their power to do that. In fact, they're bound by the EU Charter of Fundamental Rights. And then maybe just to address Carly's question, I haven't yet read the biometrics report. Obviously, though, I think it's a problem for data protection globally that we still have so much debate about what constitutes personal data and what doesn't. I would say biometric data is personal data. I mean, within that question of identification, I mean, it's a very good paper by Nadia Pertova where she says, well, what does it mean to be identifiable? Does it mean that it's connected back to something like your your civil identity and civil identifiers, or is it simply that you as an individual are individuated or singled out even in a kind of a very, I think it's the latter, and I think the support for the case law for the latter, but obviously we still continue to see this debate. And then on the COVID-19 kind of situation and then the extent to which data protection was capable of dealing with spurious claims of innovation, I think there that kind of shows that the law sits within a political framework, and that at that point in time, very few people questioned the necessity or the suitability of something like a contact tracing app to achieve its aims. All of the discussion focused on proportionality, and I think that was really for reasons of kind of expediency. It seems like political apps were being looked at as a kind of way out of the pandemic. Obviously wasn't the case, but then in terms of where you focus your energies, I think a lot of people then focus their energies in ensuring that if we were going to use contact tracing apps, they were going to be as rights respecting as possible. But I can imagine that in less politically charged kind of scenarios, you might be able to say, well, the proportionality framework requires you to consider, is this technology actually suitable to achieve COVID-19 contact tracing app context, in my opinion.
Thank you very much, both. Do you have Michael?
Concept. I think one of the issues that brings some issues around the definition of personal data is whether we can have a direct way of getting to the data or an indirect way. And sometimes we need to make use of cumbersome process. We need to have a lot of investment, sometimes technology, to trace around the data in order to identify an individual. So this one is a very complex process, but I context it's very difficult sometimes to have a completely technologically neutral definition of personal data that can bring every kind of difficult, as you have seen, problems which are arising under the AI. So
thank you very much. And with that, that will be the end of. Have a tea break, and hopefully we'll fix the technical problems in the meantime. Thank you. Thank you, Allah. Thank you so much. Thank you, Alex. Thank you.
Did everyone have a nice coffee break? Wonderful. Thank you so much for making it back in time to start our second panel. We will be talking about labor law and AI. Our distinguished participants are as follows. Chair Charlotte A. Burrows was designated chair of the U.S. Equal Employment Opportunity Commission by President Joe Biden on January 20th, 2021. Chair Burrows has advocated for strong workplace civil rights protections and robust cooperation between the commission, employees, civil rights advocates, and employers. She is particularly interested in the impact of new and emerging technologies on civil rights and employee privacy. In 2021, she launched the EEOC's initiative to examine the use of algorithmic decision-making tools, including AI, in employment. Joining us remotely from California, thank you so much. I hope you can hear me. Thank you so much for getting up at this ungodly hour. Is Professor Vina Dubal. She is a professor of law at UC Hastings. Professor Dubal's research focuses on the intersection of law, technology, and precarious work. Within this frame, she uses empirical methodologies and critical theory to understand the impact of digital technologies and emerging legal frameworks on the lives of workers, the co-constitutive influences of law and work on identity, and the role of law and lawyers in solidarity movements. Thank you so much for joining us. Here in person, we have Professor Daniel Perez del Prado. He's an associate professor at Carlos III University of Madrid, specializing in social law and labor economics. He's also a member of the university's research group on economic changes, labor law, and new society. He's the author of 4 books and more than 100 articles, and has been a visiting professor at Cambridge, the Université Libre in Brussels, and the University of Leuven, also in Brussels. He's acted as an expert for all of the institutions in Brussels. Thank you so much for being here, Professor. Dr. Johanna Wenkebach has been the scientific director of the Hugo Zinsheimer Institute of Labor Law in Frankfurt since 2019. She's a law lecturer at the Berlin School of Economics and Law and the European Academy of Labor in Frankfurt. She's the author of several books on labor law with a focus on collective bargaining, worker representation, and anti-discrimination law. She's an honorary judge at the Labor Court of Berlin and has formerly been a supervisory board member of Volkswagen and a lawyer in the collective bargaining department at the German Metal Workers Union, IG Metall. Thank you all so much for being here. Thank you, Vina. I hope you can hear me. Chair Burrows, the floor is yours.
Fantastic. Hopefully everyone can hear me. I am so delighted and honored to join you this morning. And before I launch into what we're doing on AI, I want to just say very clearly that we at the U.S. Commission, Equal Employment Opportunity Commission are laser focused on the fact that this is a transformative and important moment for civil rights in the United States and more broadly, and in the aftermath of the brutal murder of George Floyd, there was a national call, an international call for looking at how to ensure that civil rights principles are front and center, and that we answer that call for justice is something that's fundamental to our work at the Commission. And so I start there because at the beginning we talked about, well, what are we doing in AI? What are our principles? What's underlying that? And I love the theme of this conference, to race to regulate. And that is, in fact, a race, because we have to make sure that the new and exciting technologies, and I am one of those folks who love the idea of embracing what's next and cool, right? But let's be clear, we have to make sure that at the same regulatory space, in the law enforcement space, to ensure that these new technologies, we can pull the benefit without having them become, frankly, a high-tech pathway, rather, to discrimination. And so that, as I frame today, is what we are focused on in this area at the Commission. I'll begin with a brief overview of our work at the EEOC, since it's an international audience. Many of you may not be familiar with us. What we are seeking to achieve with the EEOC's initiative on AI and algorithmic fairness, which I launched last year, and 2 primary civil rights challenges that we already are seeing as we have these conversations, both with industry and with employers, with civil rights groups and unions, that I think while they're grounded, some of the things I'm going to say are in the way that we have approached it in the United States context. The fact patterns, I believe, are things that we should be thinking about internationally and globally. So first, who we are and what we do. The civil rights organization that response to the 1963 March on Washington for Jobs and Freedom. And as a result came the Civil Rights Act, the landmark Civil Rights Act of 1964. And from that, a year to the day afterwards, we're celebrating our birthday on July 2nd, our agency was opened. And what we do is we have the mission, we're the primary federal agency in the United States that is charged with enforcing the national laws against employment discrimination based on race, age, disability, genetic information, color, religion, national origin, and sex, in which we include pregnancy, sexual orientation, and gender identity. And we seek to promote equal employment opportunities for all employees, regardless status. We are agnostic to that, and by eliminating barriers in every facet of employment. So that is what we're trying to make sure we can do in this area of AI as well. We have a number of tools in our toolbox. We are regulatory, we issue binding regulations, but we also have an investigative and litigation arm. The agency itself has a budget of something around $424 million. We bring in more than that every year on behalf of employees that we help. It doesn't come to our agency. That the money that we recover goes in the form of remedies to folks who have been fired or in some other way discriminated against and need to be made whole. So we are seeing that AI is being used, as all of you know, in so many different ways. In recruitment, you can target ad nets now that the only person that sees them are the people that you've pre-selected that you think would be good employees. I don't think I have to issue spot for too many people here about what the potential problem with that could be. In selection, advertising, but also screening and interviewing. And of course, in addition, things about worker productivity. How long is it supposed to take you to finish that part of the task, right? Things like human resource professionals are trying to decide which employees can be promoted or receive bonus consequences potentially that we need to keep a pace with. The main goal of the initiative really has been to assist applicants, employees, employers, and technology vendors, and help ensure that these new technologies are used in ways that comply with our laws. And I know at the beginning was sort of framed what's new and novel. I think that was touched upon. How far can we get with our existing laws? And I think quite far, given where they are. I think the trick is we have experts in the world of technology and business over here, and experts in the world of law, and there's not a lot of overlap. So I'm excited about this conversation because it's bringing into those disciplines. And in order to answer that question, how far do we get? You have to kind of become a bit expert. Well, what are you doing, right? What is it that you want the law to apply to? And the reality is this is an evolving area. So it is a race to make sure we keep pace with that. Let me tell you what we are doing. We are, first of all, working across the administration because there are different levels of expertise here. We are working with the White House Office on Science and Technology Policy. We are working with the Department of Justice to look at that because we have overlapping but somewhat different civil rights enforcement authority. We are working with the U.S. and also the Federal Trade Commission, which looks at some of these issues from like an antitrust position, because this is a broad set of issues. Drilling down, we are making sure that it is particularly important that we be on point on that, if you will, because most people, they don't know if it was the algorithm that kicked them out of the selection process, right? So we have to be the ones that figure it out. We, for the most part, as we get charges in, so that's when someone says, I think I was discriminated against. You can come to us, that's how it starts often, and say, here's what happened to me. Well, that self-starting piece really is tricky if you don't even know that you took an online screen, right? So there's some, you may think you're just on Zoom having a conversation with me. You may not know that there's an interview process running in the background, right? And if you don't know that, how could you possibly think to come and challenge that algorithm or that online screening process that you didn't even know was occurring. So that's why it's really important for us to first have the right conversations to understand how this technology is developing. And we are doing that. We're having a lot of public listening sessions, but also conversations and meetings with experts, with civil rights groups, with business to talk about, and collaboratively to just figure out in good faith, like what is this space in which regulation is needed. So most of you are aware that unintentional biases can steep into this area because the algorithm is based on decisions that people have made about what matters, right? What's significant. So in one area that was shared just as an example, you know, if you're looking for people to, I don't know, write code for you, right? That is in first and foremost thinking about like, where do you go? So you have maybe there's an online assessment tool that you might look at, and then you bake into it what assessments you think look like success. Oftentimes that will be based on a population of people who've been successful already. And if that population is not diverse for whatever reason, you're going to recreate potentially that lack of diversity by baking in those assumptions. Sometimes the assumptions may seem to make a lot of sense, right? It could be something like, this is an example that was shared with me. How long have you been coding? How long have you been doing this? Well, that on its face, right, doesn't seem discriminatory, but it happens that if you're going to strictly use that, tends to favor men. And so if you don't know that, and you're like, that seems reasonable, let me put it into my algorithm, you're going to have potentially a skewed result. The same is true with other things that I'm sure most of you have heard about, the online selection devices that would look at resumes and compare them to the folks that were already there and discover that, well, none of the folks that work for us now have women in their sort of resumes. So let's kick that out, right? So we're looking at all those things. Two things I want to flag. One in the United States, and I hope that one of the others will get to this. I think that Vina may be prepared to talk about the proliferation of state laws practices here. I don't know, but if not, we can get to it in the Q&A. But we found at the commission that there was sort of a gap in looking at these issues when it came to disability. And so I want to flag that in particular. In our technical assistance, we just issued a guidance document you know, privacy. There's been a lot of conversation. One of the few areas where there is a strong privacy protection in US law is with respect to asking questions about disability. And that protects you if you have a disability or not. Employers are not supposed to be asking you, and it is illegal for them to be asking you in that selection process, disability-related inquiries or any sort of medical examination. So if that is happening inadvertently, if there's a screen that may inadvertently be maybe checking how your body reactions to things, that could potentially be collecting information that's related to a disability that you may have. The other issue is that you need an accommodation. You have a right under US law to accommodation. Some of these online screens, let's say, might depend on you using a remote device or a keyboard. If you have a manual dexterity disability that may, do you have accommodation? Well, if you don't know that how quickly and how you do that, how quickly you respond is going to be the but for cause of you getting that job, you might not ask, right, for extra time. You might not flag that. The other thing is that employers, I find, are often using these products that are developed by someone else. That makes sense, right? If you're not a tech company, you're not going to make your own AI selection device and do not know what's under the hood, if you will, in those selection processes. So that it may fold in things that have bias. So we are in our technical assistance document, and every time I speak, trying to emphasize with employers the buyer beware scenario, ask the questions. I am happy to go into more detail, but I think I'm running under 5 minutes left on this. So let's talk about that later if you're interested. Training staff to recognize and process requests for reasonable accommodations. Sometimes the employer is like, oh, I didn't know they needed accommodation. We had someone report to us, well, I needed an accommodation. I told the vendor said, tell the employer it went to an inbox that nobody checked. And I did not get the job. We're not letting you, that clearly, I don't think anybody was ill-meaning, but that person didn't get the job because they had a disability, and that's illegal. So we are also saying that just as we are super sympathetic to employers as they are racing ahead in this and trying to use the efficiency and the benefits of this, nobody gets a pass for doing something in contravention of the laws that are there since, in many cases, as I said at the beginning, 1964. In addition, we are looking at the ways that developers are screening for adverse impacts. And that has been overly facile, I think, in the sense that under US law, we have something called the 4/5 rule. The EEOC invented it as a guideline as part of our uniform guidelines. But it's not a be all end all. There's a much more sophisticated way to figure out if something is having adverse impact based on race, national origin, color, sex, etc. So I'm going to leave it there. There is so and while I, could go on, we had a full discussion earlier about how I am not going to do that. And respectfully, I will turn it over to my
Thank you so much. I think we're going to move directly to Professor Dubal remotely.
Great. Can you hear me okay?
All right. Once we get the audio connected.
Can you hear me? Tell me when you can hear me.
Yes. Thank you so much.
So for those of us online, the video is occasionally freezing, which makes me think that when I'm talking, I will also occasionally freeze for you. And so if you have any trouble hearing me, please let me know. I'm trying to keep my voice down so I don't wake up all three of my children. It is 3:40 in the morning here in San Francisco. So I will, if I need to speak up louder, just someone alert me. It's such an honor to be here with you virtually, and I'm so grateful to the organizers, everyone involved for making this possible. It's not an ideal way to have this conversation, but I think at this point we all are quite used to it. The talk that I'm going to give emerges from a nascent draft of a paper on AI wage regulation. The paper is rooted in law, critical theory, and ethnography, and I'm going to focus today mostly just on the law part since I have about 12 minutes. As you heard from Chair Burrow, who I'm honored to speak alongside, regulation of automation and algorithmic systems at work in the US has been most robustly discussed in terms of the potential for discriminatory recruitment and screening of candidates. And I should point out to those of you outside of the US, just at the outset, that a lot of this isn't scrutinized in courts as a regulatory matter, in large part because of recent interpretation of the Federal Arbitration Act. So most employment cases that are brought by private parties go to private arbitration. So the opportunity for inquiry into black box systems is therefore really curtailed, which is why the kind of work that Chair Burrows and other U.S. State regulators are doing is so important, because it's something that as sort of private citizens, we can't really get access to via the courts. But in some jurisdictions, we are seeing attempts to regulate, to sort of rein in potential discriminatory hiring practices. So both in the state of Illinois and in New York City, legislators have recently passed laws concerning the use of AI selection tools for hiring and promotion practices, and other states and municipalities are considering and following in their footsteps. But a place where AI at work receives a lot of journalistic and academic scrutiny, yet very little regulatory attention in the US after someone is hired is what happens after someone is hired. So that is how AI systems impact working conditions like productivity management and pay. The California legislature is very much at the edge of thinking about these kinds of laws amongst US states. So I'm going to discuss 4 instances in which regulations or attempts at regulation of automation in the workplace have taken place in California and what we can learn from these instances for future governance. I'm just going to share my screen if that's okay with you. Oh, I'm disabled from sharing my screen. Can you enable my screen sharing? It's not enabled yet. Okay, there you go. Thank you. Okay, so the first, of course, is the recently passed California Privacy Rights Act. This, as you know, is modeled after GDPR. It so far has only applied to consumers, but will in the coming year, January 2023, will go into effect for employers, employees, and their independent contractors and subcontractors. It doesn't prohibit, like GDPR, the collection of personal data, but it preserves the right to correct and request deletion of that data. Similar data protection laws are going into effect next year in at least 4 other states that I could find. What I have here, it's impossible for you to read, is just showing you sort of how it's the very little impact that I believe, at least initially, the CPRA will have on workers. This is just at Walgreens, which is one of our local drugstores. Alerting workers to what kind of personal information that is being collected on them. Sort of very, very small print in the back of the store, not something that you would sort of look at or think about. I think that we are far behind our European and British counterparts in conceptualizing how to use this statute to improve working conditions once it does go into effect for workers. But I know of at least one instance in which workers in California who experience extreme workplace surveillance are attempting or thinking about using the CPRA to at least discover the types of data that's being collected on them. And in some ways, this is sort of a reverse attempt to understand the regime of algorithmic management in their workplace. The idea is that if they know what is being collected, perhaps they can understand the systems that attempt to control their behavior and, most critically, their wages, which I will get back to. Another really important bill that is currently being considered by the California legislature, it is in committee right now. It's called the Workplace Technology Accountability Act. It's being brought by our esteemed Assembly member, Ash Kalra, and it would be sort of the most robust effort to regulate AI that we've seen in the entire country. So in addition to conferring the right to workers to know, review, correct data that's collected from them by their employer, it limits the ability of the employer to use that data beyond the specified purposes. It imposes some limitations on the collection and use of the data via electronic monitoring, which I'll go over in a second. And it also imposes some outright bans on the purpose and effect of using automatic decision systems. So specifically, it does this. It says that the employer cannot collect or interpret or use worker data unless it's for these very specific enumerated purposes. Most importantly, what this does is it cuts off downstream third-party analysis of worker data, which is there's this whole new market that's being created in the US of data companies that collect all of this information and then sell it to future employers, which, as you can imagine, has a lot of potential discriminatory impacts. So this employers can continue to use this data to monitor production, to assess worker performance, and to administer wages and benefits. And I sort of have a critique of this. It leaves in place the sort of basic problems that workers are facing. So it also prevents automated decision-making systems, bans their use in predicting worker behavior, which is really quite important, bans them in the use of any sort of exercise, if they're being used to prevent exercise of legal rights, and also perhaps most controversially, and I'm sort of interested in whether this stays in the bill or not, but it bans the use of facial recognition to make predictions about how workers are feeling, which is sort of, a huge area of critique that those of us in the academy have. Finally, there is this AB 701, the Amazon warehouse bill, which has passed, went into effect this past January, brought by Assemblywoman Lorena Gonzalez, who is now the head of the California Labor Federation. She's left public office. And what this workplace bill does is it doesn't so much focus on the AI, but it actually addresses the harm caused by the AI, which is one way that we can think about future laws. So as opposed to, and I'll mention this in a second, but as opposed to thinking about this in terms of sort of the particularities of data and technology for workplace regulation, we can think about sort of nipping this data, the use of data and ads at work by just regulating the harm. So what it says is that workers have to have access to current productivity measures in warehouses. So this is in response to wearables. So as opposed to sort of being forced to work harder and longer based on what the AI interprets about your bodily movement, it says that workers have to be given a set quota when they are hired, or at least 30 days after being hired. And that quota, if it goes up, is sort of subject to negotiation. And the quota cannot prevent meal and rest breaks. It cannot prevent bathroom breaks. And if companies do this, the warehouse workers can get a court injunction. Also importantly, if the injury rate in any given warehouse is 1.5 times higher than the average industry rate, and this is of course true for Amazon warehouses in California, then the state has the power to initiate an investigation. So that's been, really, really exciting. Governor Newsom passed it and signed it into law, and it's now sort of available. It has not been utilized in any way that I've seen, but certainly has changed shop floor practices. The last piece of regulation that I'll talk about is Proposition 22, which many of you have heard about. It's more talked about as a form of deregulation than a regulation, but it is nonetheless a law that is currently being challenged in courts, but nonetheless is in effect right now. And it regulates work for transportation network workers and delivery network workers. So that is food and transportation workers who are deployed via app, and it regulates them most particularly regulates their wages. And the reason that this sort of is important in thinking about AI regulation is because increasingly in both not just in the gig economy, but beyond the gig economy, we are dealing with the reality of dynamic pricing, what I call labor price discrimination. And so what the Proposition 22 does is create what I call the new racial wage code, which is that for a whole sector of the population that is primarily immigrants and people of color in the US, almost 80% immigrants and people of color, these people no longer have access to the minimum wage. Instead, they are paid only for engaged time. And what engaged time is, important for you to understand, is the period of time after a worker is allocated a job. So that sounds like piecework. It is piecework, but it's even worse than piecework because it is algorithmically determined. So industry-sponsored research suggests that workers' non-engaged time, that is time for which they are not paid under the law, is roughly 40% of all the time that they labor. So, cutting their wages in half. But crucially, the amount of engaged time is completely unpredictable, rooted not just in customer demand, but also in a black box system of algorithmic decision-making that determines how and when any single worker is allocated work. And even worse, all of the so-called benefits of Proposition 22, like a healthcare subsidy for workers who already have health insurance, is only available to workers if they labor for a very specific period of engaged time. But that time is not determined by how long a worker decides that he is going to work. That time is determined by the company's algorithmic systems. So since Proposition 22 has passed, workers have told me that as they get closer to the number of engaged hours necessary, they sort of stop receiving work, thus making these so-called benefits unavailable to them. So too has the amount of money that they make during this period of engaged time become hidden behind a black box. So it's no longer based on a percentage of time and mileage that they can sort of understand. Instead, it's based on secretive algorithms that have the capacity to learn from driver behavior to estimate what is the lowest fare a driver is willing to accept for a ride, resulting in what I am calling algorithmically enabled labor price discrimination. We can understand this law as legalizing an AI-facilitated working condition problem instead of addressing it. Essentially, black box labor price discrimination is sort of the law of the land for transportation and delivery work. And importantly, this has stifled a really robust policy debate over how much workers actually make, because it essentially doesn't matter. So the paper itself, which I can't wait to finish, sort of tries to understand the degree of precarity, uncertainty, self-doubt, frustration, lack of control, and fear that this leaves workers with, using ethnographic engagement with drivers themselves. Since I have just 30 seconds left, I will tell you what I think needs to happen in this arena, in particular around algorithmic decision-making and wages, because as I said, this is now sort of seeping into other sectors beyond just what we have called quote unquote gig work. I think that we need to think about this in the sense of abolition. So to date, many of the forms of regulation that I've discussed in regulatory attempts have sort of fallen into these two categories: data guardrails, notice, consent, correct, not particularly effective. AB 1651 and AB 701 does try to address algorithmic decision-making systems by actually curtailing their ability to do certain things. But what I am suggesting is that in some cases, we just need to abolish the use of the collection of data and the use of algorithms more broadly. And I want to suggest that this is a really particularly important moment, and I'm so glad that we're having this conversation right now, because it's a moment in which we cannot just make work as bad as it's ever been, just go back to making sure that workers have the very limited rights that they have, but we have the opportunity to reshape cultural and legal norms about the prerogative of business in relationship to labor, actually make work better in this moment. And this isn't a politically impossible conceptualization. I use the term data abolition and not redlining or not bans, because I understand particularly the kinds of surveillance that I'm talking about, labor price discrimination in specifically as a coercive racial project, because as in the US, workers who labor in these spaces, in warehouses, in the gig economy, the logistics economy, they are primarily, as I said, immigrants and people of color. And so following Black feminist theory and W.E.B. Du Bois's idea of abolition democracy, I'm conceptualizing and advocating a theory of data abolition. I'm proposing thinking about abolishing data and algorithmic systems of exploitation within work, both in and outside the labor market, and rejecting forms of social, political, and economic control that take the digital artifacts of our lives and use them to extract capital value, borrowing from the kinds of tactics that we've seen in the criminal justice movement in the US. And so I'll end there. That was a lot of information and a little theory, and I look forward to our conversation.
Thank you, Professor Dubois. Professor Perez de Prado.
UK. It's always a pleasure visiting this. It's even a greater pleasure if it's for discussing on AI, especially connected to labor law. We have, I would say, a very effective and efficient controller, but let me use the technology to control myself as well. My aim for today is trying to obtain useful lessons from the Spanish experience. And in order to, by the way, and in order to achieve this objective, I divided my presentation in 3 parts. The first one is the prehistory of the AI regulation or the AI normative reaction in my country. The second, the beginning of the history, that is the moment in which we are now, and finally the lessons themselves. Concerning the first part, such as in other areas concerning digitalization, the first reaction was given by the courts. And here we can find 2 different approaches. From the perspective of the lower level, the main issues, the only issue is the reaction against the impact of digitalization on employment. These cases here are connected to dismissals. Maybe the first one is the most important one because it became quite famous in the media and in the Spanish audience because it was a lady dismissed by a bot. The bot covered all her tasks and the company decided dismiss her. And the reaction from the court was given the maximum legal protection in my country, that is the maximum dismissal compensation, the compensation for unfair dismissal. Maybe this reaction is not effective enough. Some scholars in Spain says that this is like you say stem the tide. We say put gates outdoors. Anyway, this is the legal tool that we have to react, and this is the reaction that these courts gave to this problem. And what about the Supreme Court? In the Supreme Court, the cases that we find are completely different. And they focused on analyzing how the algorithms can be used, such as an evidence. In the first case, in the case of the, competence matrix, it was an algorithm who decided who was going to be dismissed in a collective redundancy. And in this case, the court considered that the reasons given by the company, that were the reasons given by the algorithm and the algorithm itself were objective, whereas in the second one, the Ericsson case, it was a case in which an algorithm decided the assignation of tasks in a context of a strike. And particularly, the algorithm decided to assign those tasks to workers outside the company. According to the Supreme Court, this is not the usual functioning of the algorithm. The algorithm was manipulated because the usual behavior would be assigning the tasks to those who are inside the company, within the company. So here we can see also how the algorithm can be used just to prove that this is not an objective reason to do that. What about the beginning of the history? Well, in the beginning of the history, we have, it was mentioned very early this morning, the Writer's Law. The key point concerning the Writer's Law is not the content. The key point here is that the Writer's Law is a tripartite agreement between both social partners and the government. Nevertheless, concerning the content, we have two main areas, two main legal tools. On the one hand, the rebuttable presumption. Here we have, scholars have a huge discussion concerning the legal nature of this rebuttable presumption, but today is not the protagonist. The protagonist is the second one, the reform of the Article 64, providing a new workers' representatives right, the right to be informed concerning the functioning of the algorithm. This article is not only a right that would be a good advance, it is also a call to social partners to negotiate the algorithm as well. And social partners decided to answer this call. Actually, we have two agreements after the law. The first one is the sectoral agreement for banks, but the most important one is this one here, the agreement in the company Justit. In this agreement, we can find clauses, common clauses, traditional clauses, the adaptation of traditional clauses to the reality of the platform work, because this company is a platform work, is a platform, such as in the areas of working time, salary, etc., and new rights concerning digitalization, distinguishing these two perspectives: individual rights, such as the right to disconnect, the right to be informed, the right to human intervention, particularly knowing when the person is talking or contacting with a person or a chatbot, etc., etc., etc. Concerning the collective rights, here the agreement is implementing the law by deciding what kind of information is going to be delivered and what kind of information the company is not obliged to provide. Additionally, the agreement creates a commission algorithm, commission algorithm, a peer commission in which these kind of issues are going to be discussed, in which the information is provided, etc., etc., etc. But negotiating the algorithm is not an easy task. And as a consequence, the government decided to help social partners to negotiate the algorithm, and it published this guideline concerning algorithm management. Actually, yesterday, the English version was published, so you can find it in the Labor Ministry website. And I would like to give you the key aspects of this guideline. First one, definitions of algorithm black box. From a very general perspective, to make understandable, comprehensible for everybody, and especially for the negotiators. Secondly, this is not only an employees and workers representatives' rights, but also a company's duty. And as a consequence, the guideline highlights these two perspectives, the individual one and the collective one, and the legal ground for each one. In the case of the individual right to be informed, it is based on the Article 22 of the General Data Protection Regulation, and in the case of the collective side, it is based on the new Article 64 of the Workers' Statute, the Spanish Employment Law. Also here in the number 3, we have that the information that can be provided in detail, what kind of information the company is obliged to provide. Fourthly, we have also here that there's an obligation of negotiating the algorithm, except for in one case, that is the negotiations that are recognized by law. That is the collective redundancy, geographical mobility, substantial changes in the working conditions. In these cases, such as the law is recognizing a negotiation between social partners, if that negotiation is affected by the algorithm, such as in the judgments that I mentioned before, the guideline considers that negotiating the algorithm is an obligation, despite the general rule, as it's highlighted here, is that there's no obligation. There's an obligation of consulting the introduction of the algorithm, and this is based not in an explicit article of our workers' statute, but derived from other general articles in the Spanish employment law. There's an impact assessment based on the Article 35 of the General Data Protection Regulation. And finally, the information tool, that is a set of questions that the company and the social partners, the trade unions, the workers' representatives must follow in order to know how they are implementing this guideline. The last part of this beginning of the history is data protection, and this case concerning Mercadona, that is a supermarket. Here we have a judgment and two resolutions from the Spanish Data Protection Agency and the Catalan Autonomous Agency as well. And the key aspect here is it was a case of biometric control. And the aspect here is that both the judgments and the agencies consider there's no legal ground, neither in the regulation nor in the Spanish law, to apply this kind of this supermarket in this company. What about the lessons for the future? Well, first of all, collective bargaining is a key aspect. Without a doubt, is a key aspect. But as I've mentioned before, it is not an easy task. And that means legal intervention to facilitate social partners to negotiate, such as in the Article 64. Legal intervention also in some areas in which the governments consider that that area it is necessary to be regulated by law, but also technical intervention. I think that the guideline is a good idea to help social partners to negotiate the algorithm, because we know that this is not an easy area. Second, the right to be informed. Here we have two different approaches with two different grounds, a national article, a European article, and there's a clear mismatch. So it is necessary to regulate both perspectives, the individual one, the collective one, trying to guarantee the similar level, and maybe the transposition of the directive on transparent and predictable working conditions is a good opportunity for member states to achieve this objective as well. Thirdly, the discussion concerning the subject must cover only workers or also self-employed persons. And finally, the data protection, such as the it was mentioned also in the previous roundtable. We have some areas in which the regulation is not enough. Despite the regulation and even the national laws, such as in the case of Spain, is a very huge advance in the regulation of this particular area, we can find others, such as the biometric data, in which the problems are still there and in which the law must intervene. And by the way, in the case of the Catalan authority, it opens the possibility also of regulation by collective agreement. From my personal perspective, it would be possible only if the law permits the collective agreement to intervene, but there we have also the debate. concerning the powers, concerning the function and goals of collective agreements to regulate also data protection in these particular cases. And that's all. Thank you very much. Muchas gracias.
I'm going to briefly exercise my chair's prerogative to do a small piece of translational explanation, which is that for those of you living possibly outside the European traditions of social dialogue and labor law, the social partners are the workers' representatives, often the trade unions, sometimes the works councils. And I do this because we're now going to hear from Johanna Venkebach. Thank you.
I think I have to cut that to not be cut off some of my points I want to bring here, but no, it's really great to be here. And finally, after 2 years debating AI, meeting people in person who inspire us in our scientific and political work. Thank you very much for having me. And yes, I want to focus on an aspect we haven't heard of so far, but I think is very important. And I hope that maybe German politics and social partners agreement can inspire discussions and politics in Europe and beyond. And this is the idea of democratizing AI, artificial intelligence, because important aspects of regulating it in the field of labor law. I do not want to start with legal arguments on this, but with empirical data we gathered in our foundation, searching on people's position towards new technologies and towards democracy in general. And I think it is neither surprising nor should we ignore these results in the debate on regulating AI, which is firstly that the effects of AI and what we discuss as transformation, at least in the German debate, are a class matter. And we heard about gender bias in AI, discrimination risks, and racialization. And our data points out clearly that the chances of the improvement of working conditions are divided inside the workforce, and the higher your qualification and income is, the better the chances are. And this is also the position of people towards new technologies, that your working conditions will be improved by AI. The second finding I want to bring up here is that the trust in democracy is where workers experience recognition, fairness, and autonomy. A lack of these factors, on the other side, we have very fresh findings on this, and looking at the political situation in Europe and beyond, I think this is something we have to integrate into this debate. So strengthening democracy and participation in the world of work, in my eyes, means securing democracy in general, especially in processes of transformation, as we have with the use of AI and new technologies. And the idea of workers to have a voice, to be a citizen inside the workshop, is what, actually with blood and riots, has led to workplace co-determination in Germany now more than 100 years ago. And this concept of co-determination has successfully managed other industrial revolutions. I mean, using technology in order to make work better, safer, less unhealthy, more secure, and to raise income of workers by gaining more efficiency. AI has the potential to do this, but we need to address and regulate the risks. Best what the risks of AI are in each specific workplace. And who knows best the fears and interests of workers in specific workplace situation? The answer to this question is another idea of co-determination. Be done by politics or by state institutions, but have to be found in each workplace on the plant level. And they have to be found involving the workers in a democratic process of co-determination. On AI also way before the government started to even concretize its ideas on regulating AI. We might have, I can't go into the details debates now, but maybe we can come back to this later in the Q&A. And I neither will have time to explain the German law on co-determination in general, but I want to bring some important aspects for you to have an idea of what I'm talking about. Works councils are elected in a democratic process. Having a works council is compulsory in a plant with more than 5 employees, once there is an initiative to have an election process. Works councils have no right to strike. Like, it's different from labor unions, but union activists can be works council members, and many of works council members are active unionists. And so, for example, there was a great Amazon plant. There was a works council election where the labor union list of Verdi actually won. So from now on, there will be labor union influenced and guided co-determination in an Amazon plant, which is progress actually. And then works councils have no right to strike, but they have enforceable rights to ensure, and I'm just mentioning the AI relevant cases here, health and security of workers, of the workforce by the employer, and very important also in the field of AI, I think we haven't mentioned that aspect yet for labor law, education and training. Make the enforcement of law more effective because they control the employer as he's applying the law and collective agreements. And I think this is a very important aspect for the discrimination issue you've been mentioning and we talked about, because we do have empirical data on the lacks of enforcement of law, especially in the field of anti-discrimination law. It's not very surprising that people do not like to sue their employers in individual claims if they want to keep the job. Of law enforcement is much more effective than just having individual rights, that people have to enforce their rights on their own. And I think this is a very important aspect for the regulation of AI in labor law. We have to have in mind that we need collective law enforcement besides, of course, individual remedies to enforce not only anti-discrimination law, but also data protection. So after giving this short overview, I hope it doesn't surprise you when I now say that the first regulation the German government chose to regulate AI in the world of work is actually by strengthening works councils. In our eyes, they haven't gone as far as they could, but the law they issued in 2021 was a very good first step. And I and worldwide debate on regulating AI for labor law. What they did is first making clear that the rights of the Works Council in designing working environment and procedures does cover the use of AI. They make clear that co-determination rights apply where personnel is selected with the help of algorithms. These processes you've been talking about. And they pointed out that works councils must assess the introduction of application of AI. We know from the practice that this many times doesn't work because like other providers. So there is practical problems with approving this new or applying this new law. And a very important aspect, and I think this is something that can be regulated beyond like our specific system of co-determination, which is making sure that the employer has to pay for IT specialists when the Works Council asks for them in order to help him as he makes use of his rights, because you need to understand AI and the techniques in order to be able to assess risks and regulate them. And we also have very good examples for collective rights and the inclusion of co-determination into regulation of AI in the draft directive of platform work that has been mentioned before. The rules on transparency of beyond platform work in my eyes. So I think those regulations should be extended. I'm talking about Article 9 and Article 14 of the draft directive of platform work. And we just heard about the good examples from the Spanish law, which are also strengthening collective aspects of regulating AI on the plant level. The bad news is I have 5 minutes left. But the bad news actually is regarding to my subject that co-determination is under pressure. And that is especially true in the field of tech work. And this is actually due to changes happening through the use of new technologies. We have only 41% of the German workforce being represented by works councils. It could be many more, and the number is actually that high because all the big plants do have works councils. And we see very effective and strong avoidance strategies of especially tech firms. You're laughing because you've been there in practice dealing with this. And actually, the labor courts are dealing with these strategies too, this is especially true for platform work companies, really trying to avoid elections of works councils up to illegal methods. And then I think this is both a question for lawyers and for labor unions, because this is also about solidarity in practice. And so, like, organizing solidarity is always the first step in order to reach a collective agreement. This has to be collectively bargained also on the workers' side. And there are some factors I just want to throw in to kind of make up the field of problems. It's big data that makes it easier. I wanted to ask that question in the first panel, but the time was over, to avoid and analyze unionization, especially on the internet. And then algorithms do create a work without jobs. They create work without a common workplace, creating solidarity and trust, which is like the first step towards collectivization. So Jeremias talked about the loss of agency, and I'm talking about the loss of collectivity and solidarity, which we have to have in mind when talking about labor law and AI. And my last aspect I want to bring in, having this in mind, is that a very important rule is now planned to be implemented by the new German government, which is regulating digital access of workers' representatives to workforces. And here again, I can refer to the Platform Work Directive draft, which also has a very important rule on that, making sure that workers in digitalized, individualized workforces can have contact with each other, communicate with each other, and that they can reach the workforces through digital techniques. And we do have labor law conflicts about this digital affecting platform work again. We have these conflicts in big traditional industry companies who have, since crisis started, all of their workforce in home office. and the labor unions can't reach the people with handing out flyers as they have done in the last 100 years. So this is an issue we have to address, and we also legally have to address, in my opinion. And in my last minute, I want to bring up one, well, revolutionary and radical idea, because I feel that discussing from a worker's perspective, you kind of always defend saying, the labor unions are stopping progress and technologies from advancing economy. So why not bringing up something that the workforce asks for in the process of implementing AI? This idea just rewrote the law on co-determination to make it suitable for the 21st century. And we have many ideas on how to change and adapt co-determination law to digitalization. But one of the ideas is giving people time for democracy in the workplace. So we suggest 1 hour of democracy time for workers in the plants each week, in order to be able to discuss changes of their workplace situation, to discuss how techniques function or do not function, and to strengthen their autonomy and participation. Because in order to have a democratic workplace and democratic technology, working people need time for this. And this is lacking. So I'd like to finish with this outlook that maybe inspires our debate. Thank you so much.
Tausend Dank, Johanna. I'm now going to introduce your discussant for this panel. Dr. Sarah Myers-West is a research scholar at the AI Now Institute and a visiting research scientist at Northeastern University's Network Science Institute. Her research focuses on the intersection of technology, labor, and platform accountability, and is published in a variety of journals, including the Social Studies of Social Science, Policy and Internet, and Business and Society. She's been featured in a very wide range of media outlets and holds doctoral and master's degrees from the Annenberg School of Communication of the University of Southern California. Dr. Myers-West.
Thank you. How are we on time? I guess is the first question. We're okay? All right. More of a conversation. Thank you all for such a wonderful, what I hope will be a very rich discussion about some significant challenges that we're facing, as well as some frameworks that are developing to be able to overcome them. So I just want to synthesize a few points that I think came out across all of the papers. One, I think, is a clear. We see widespread deployment of automated decision-making systems at various points in a person's life as a worker, from how you might find out about a job, how you're selected for a job or not, your experience in the workplace, how your wage is determined, the conditions under which you work, and also potentially the termination of your position. I think we also saw across these presentations that a lot of times in practice, the way that these systems are working, although they're often presented as, in the interest of objectivity, or sometimes marketed as exacerbate existing forms of inequality. And this is particularly significant when you look at who are the workers that are most directly affected by the use of these systems, which, as I think every panelist on this panel has noted, predominantly have most deleterious effects on immigrant workers, workers of color. Another theme that I think is sort of environmental but important to situate the discussion in is that this is a moment where the boundaries around the workplace are much harder to clearly define. That many of us post-pandemic especially may be working in workplaces where you're not going into an office, the working environment can come into your home in a much more potentially invasive way, where, you know, the workplace itself, if you are going into a warehouse, or if you're, you know, working from within your car, you may be exposed to new kinds of surveillance that you might not have been exposed to years ago. Where, you know, the device that you're using, if you're a gig worker, is both personal and also something that your employer has access to. Get to around how notions of consent extend or not in workplace contexts, that there is a unique dynamic to the relationship that you have with both your employer, but also the vendors that may be selling the technology that is mediating your relationship with your employer, and how consent needs to be carefully considered in ways that are very distinct from, you know, other consumer relationships. And then another thing that I think really questions around agency, and particularly finding space for agency in the face of considerable information asymmetries, both in the often invisibility. You might not be aware of the many ways that automated systems are determining your life chances, but then also your ability to do something about it once you know that a decision has been made. So I think that's a very brief summary of some of the things that we're up against in the items for discussion around what do we need in order to effectively regulate AI. And there were two there that really stood out to me. Great, a shift from thinking about individual rights and individual frameworks, and moving toward the collective, and how to effectively make that shift. And then the second that I would love to get into, and maybe I'll start there, is what kinds of preconditions do we need in order to make accountability frameworks most effective? I think Chair Burrows started us off with a discussion about civil rights. Professor Winkelbakken spoke about, you know, country contexts where there are very strong, you know, existing structural frameworks for. I think you spoke about a number of different state-based frameworks in the United States that are taking a variety of different approaches to creating those underlying conditions for regulation to take place. But I'd love to, you know, delve a little bit more into the concrete, and maybe I'll just open it up there for discussion. Chair Burrows.
So just so I understand the question, there was a fairly broad lead-in.
Yes.
You're excited for this. You say concrete, you want to talk about fact patterns or context? When you see context, more context for the context question.
Oh, that's a. I think we could take it in either direction. I know we have a combination of folks who are coming from thinking through legal frameworks where you might want to talk about the fact patterns. I also know that we have some folks who have done more empirical work, so I'm happy to take it in either direction.
If I could just
Well,
jump
I'll start
in.
with this, because I think that, you know, I come from the anti-discrimination employment side, not so much the labor side, which in the US is divided in this way. And one of the things that I observe all the time when I am in Europe or talking to folks who you'll hear is that my friends at the National Labor Relations Board may disagree with this, but I think that the European law has a lot to teach us in the union area. But on the other side, the American law, particularly with some of the robust kinds of remedies, has a lot to teach Europe as to anti-discrimination. And that comes in part from where you saw some of the movements and some of the history of those movements while they were very me is that connection, because you know, for instance, we talked about, and I appreciate the discussion of wages and how these algorithms, we actually have one of our litigated cases kind of decision making that happened with respect to how you were going to set pay. And it really looked at what employers had done, you know, your evaluations over time. And that those things that they had said were important, those evaluations, kind of baked into this algorithm. Okay, here's how you're going to be paid. Well, it turned out it had, for some reason, based on what these individuals had decided, a discriminatory impact on women, right? Women were going to get paid less based on this neutral seeming thing. And so I raise it because sometimes impact, and you're in a workplace where there are not a lot of, in this case, women, although here it was not one of those industries, but there are certain industries like that. What you may or may not get is a lot of worker voice through the union. And I think that context is important to remember. I have seen it, I'm more familiar with actually Germany than some of the other countries. I have seen that when you are the woman who is being sexually harassed in a mostly male workplace, which we also know from our work on Me Too issues, is actually a warning signal that harassment may be more likely. You have fewer women or fewer of whatever racial demographic. So I think that that is part of, I'd be interested in hearing the things that you're talking about. But if you're only got a few people of a particular demographic in your works council, or that has not traditionally been the history, like let's go and with the Works Council, right? How do you bring that together? Because I think that is, in terms of truly covering all these issues, that probably merits some consideration.
Professor Winkler.
Very difficult question.
That's why you get to answer it.
Before I answer it, I just want to say that this idea of learning from anti-discrimination law, and we just had the debate this morning on actually how anti-discrimination law from the US and the UK has inspired European anti-discrimination law that now doesn't apply in the UK anymore, sadly to say. But and I think one important aspect coming from discrimination law is the question of the burden of proof, because we talk about AI being a black box, and the Platform Work Directive already addresses this aspect of making it hard to enforce labor rights, because it's very hardly possible to prove how the algorithm has worked and thus maybe discriminate. So I think we learned that in anti-discrimination, when humans did the process, it was very hard to prove a discriminatory motivation. I mean, we had hundreds of papers in Germany saying, oh, now we're like mind controlling people with this. It's still this, like, which is a racist argument actually against anti-discrimination law. But I think this is something that should be adopted for regulating AI, this shift in the burden of proof and transparency rules in order to make it clear. And then, of course, you're right, like Six and I have worked for the Metal Workers Union. I think the workforce is 70 or 80% male. And especially in Germany, there are big numbers of migrant workers, but still, it's like in politics, the people standing in the front lines, also on the workers' side, are white males. It's slowly changing. We have a quota for women in the Works Council law that since 20 years, and you see the numbers are rising, like the quota is effective. We're now debating migrant quotas for politics, and of course, there's also active labor unionists who want to bring those people into works councils. We have some migrant worker works council leaders actually, and I just saw one of them who's doing really great work, but I was wondering if he's actually identifying as a migrant worker. This is sometimes a mind issue, but what we say from a feminist perspective is we need I don't get the positive action is the word. We need positive action to make like quotas. So if you use AI in a process of hiring, for example, and if there comes out there's only 10% women being suggested for interviews, this has to be revised. Just saying like this, the number is just too small. And I think we need it because to change those biases in the world of work, our experiences by having a chance for people to claim for themselves to being discriminated doesn't really change the structures, and we need quotas, and especially for AI systems to really bring forward a structural change.
If I can add just as a little example, it is in that case, 17 in 21 employees who were dismissed were affiliated to one of the trade unions in Spain, Comisiones Obreras. The data are crystal clear, 17 in 21. And despite this data, the Supreme Court, if you remember, considered that the collective redundancy was fair because the algorithm shows that there are objective reasons to dismiss these 17 in 21 unionists in that company. So that's, I think that is a clear example of how it is very, very difficult to prove any kind of discrimination when AI is involved.
So could I respond to both of those points actually just very
Sure.
Why do we have to get
Oh.
Vina in?
Oh, sorry.
Yeah.
Hi there.
Oh, no, it's okay. I was just going to.
We don't hear her. Wait, Vina.
Oh no! Tell me, can you hear me now?
No, it's not you. It's here.
Oh dear. Well, maybe Chair Burrows should start since you can't hear me.
London
Maybe Chair Burrows, you can respond, and then I also have a question for.
Okay, just give me the high sign and I'll stop as soon as she's ready, or we're ready for her. Just really quickly, 3 things occurred to me that might be helpful from the US perspective on this, although, correct me if I'm wrong. You back? Yeah, okay. Just give me the high sign. One, just you talked about the burden shifting with respect to burden of proof. In US law, if you're looking at adverse impact based, from an AI system or anything else for that matter, in the first instance, you figure out if there's adverse impact. And that's a question, a statistical question of math that is much easier, I think, to figure out than the validation, which is the second prong. And that's where some of the complexity comes in. But the burden shifts. And it's the user of the artificial intelligence that has to prove, well, no, this is job related and consistent with business necessity. And that's a matter of proof. Then if they meet that burden, the burden shifts back to the complainant to say, well, there's a less adverse way to do that, notwithstanding, okay, you say it's valid, but you could also get the same result in this other way. So I think in that sense that when it comes to this, well, what is it that you're doing and how does this work? It's not the complainant's burden, this adverse impact. So I think that's one thing. How are we doing on sound?
Is Vina?
Oh. Please finish.
Oh no. Yeah, try Vina.
They think it'll work.
Can you
Try
hear
one more
me?
time. Yes.
Yes.
Okay.
Well, I don't want to interrupt your what you were
No,
saying.
I was
Chair
filling time
Burrows.
for you.
Okay. Well, thank you. So I'm now sort of forgotten what I was going to say, but I guess there are a couple of things I wanted to say just with regard to the question, which I understood to be sort of what are the preconditions to make this possible. And there's a prevailing debate in the sociology of law about whether collective action comes before new laws or whether new laws can facilitate collective action. And I think that this is sort of a useless debate in some sense, but we do see in the US relatedly sort of unprecedented for our times interest in organizing one's workplace, in having collective power at the workplace. And I think it's important to sort of remind ourselves that sort of nothing is ever given, it's fought for and demanded. And the reason in California that we have these laws is not because, you know, we're so progressive in California. To the contrary, it's because we have a strong union presence, and unions are working very closely with the legislature and also with the workers that they represent to make sure that working conditions are addressed through laws. I think that we should also understand AI regulation in the workplace, and I think this is what Johanna was saying, as union busting, right? Like it's not always about productivity or wages. It's an attempt to, even when they're not actually union busting, to intimidate workers from engaging in their collective organizing rights. And so I would love to have a lot more conversation about what that looks like, how that can be facilitated, and especially in a place like the U.S. where we don't have works councils, we don't have a strong tradition of social partners being part of the conversation, particularly in the last 40 years. I think that has to necessarily be part of what it means to regulate AI in the workplace.
I think we have time to take two very short questions from the floor.
Right there.
Valerio.
No.
No.
Thank you, Valerio De Stefano, York University, Toronto. I have a question for Veena, if technology assists us. I was wondering, Veena, first of all, thanks so much for your talk. I think some of the initiatives we are seeing are in a way siloed. So there is an initiative on privacy, initiatives on discriminations, maybe something about co-determination rights. There is not much a reflection on how all this technology impacts on managerial prerogatives by amplifying them and basically straight away. So some of the technologies should not be implemented unless certain procedures and certain safeguards are implemented. I was wondering if you have some thoughts on that.
That is precisely what I'm arguing in this paper, and I'm sort of using the wages, the focus on wages, to think more broadly about AI abolition. And I think that what you're saying is hugely important in terms of how we're compartmentalizing regulation in a way that's very artificial to how the worker experiences AI, how they experience surveillance, how they experience how data impacts their working conditions. And I really want to emphasize something that I said earlier, which is that this is a particular moment in which we can make things better. So not just as bad as they've ever been, but actually shift how we think about the managerial prerogative, shift how we think about employer power, what businesses should be allowed to do, what they shouldn't be allowed to do. Chair Burrows talked about in employment discrimination law, the development of this idea of business necessity and job relatedness, which is a burden that the employer bears. It's a very limited burden to prove business necessity and job relatedness, in large part because of the business prerogative, because we have this cultural notion that companies own property, and in some sense workers are their property, and they should be able to do sort of whatever they want to with their labor as it relates to productivity. And I think that we see that very much reflected, for example, in the workplace technology bill that I spoke about, which is really amazing in so many different ways, but leaves untouched the employer's ability to use data and AI as it relates to productivity. But this is the primary problem. We cannot leave that untouched. And so I think that many of the sort of the problems that we're addressing actually have to be addressed through not just collective bargaining rights, but actually addressed collectively, not just with worker voice or worker input, but actually quite much more radically with a complete sort of re-envisioning of what it means to work in this world right now, especially if you're sort of a marginalized, vulnerable, disempowered person that sort of exists outside of centers of global power.
Thank you. That was an amazing discussion. Picking up what you said about changing our thinking from individual to collective perspectives, harms and redress. What do the panel think about the merit of establishing a wider preemptive obligation to evaluate risks and harms at work or beyond it, which incorporate individual types of impact assessment like the DPIA, but aren't limited to it? I'll cut it there.
I mean, we haven't criticized or even mentioned yet the draft AI act coming up in EU, and this is actually one of the critiques that we have, that it's kind of, I mean, there's various problems we can't discuss now in the last 5 minutes, but it's very narrow. And it's too narrow to actually cover reality of working world. And I mean, the more it leaves out, the less it's going to help, and the bigger the possibilities are to go underneath regulation, individual law, and to enforce them. Maybe so far for me. I don't know.
Maybe a
very big question.
One last question.
Thank you so much. I'm currently studying philosophy and artificial intelligence. I have a facial difference, and so ableism in biotechnology, specifically. Also, as a philosophy student, we talk a lot about definitions and the impact of definition, bias, all of this. I think disability is so multifaceted, and it changes so drastically, even how we define ourselves as people who are disabled. And so I guess I'm really interested on the difference between racism in AI and ableism in AI, and how we categorize disability and specifically facial differences in facial recognition technologies, and how that will impact the law that governs these technologies and how we have these discussions. I'll stop there. Thank you.
I think that's super interesting. If I could jump in on that, that's something that right at the beginning I briefly ran through the fact that we started with disability as take a look at this. Some of the state laws that Professor Duval talked about are kind of, I think, not for the New York City statute, not really covering that. Quickly, the big difference in, from my perspective in US law is that this adverse impact, you have to do the statistical piece, that would happen with race and sex. That is in the context of like those situations under Title VII. Under our Americans with Disabilities Act, because there are so many different disabilities, right? You don't need to have, many blind people, for instance, take your reading test to be able to say, you could just have one. It didn't work out for that one. It's going to tend to screen out blind people because they're not able to read on the screen. Or this is a silly example, I recognize. So that is one big difference. You don't need a large statistical pool and do that adverse impact. If it's screened, sort of algorithms that look at that, those are things that in some instances collecting that information in the first place is not okay, but also you can get an accommodation. And so there's not a separate accommodations piece. Those are the two separate things that I think are really important precisely because of what you've talked about in that there are so many different kinds of disabilities, and we're still learning about that, that you have to be cognizant of that as a different legal framework and a different.
I can add one aspect, because we've just been revising the German anti-discrimination law for disabled people, which applies in the public sector. And one thing is discrimination of AI, and wherever statistics create a norm, it's like obvious how big the risks are. But it's also about access to the advantages of digitalization and AI, and making those like positive aspects accessible for everybody. So we also discuss digitalization, and AI is one aspect, not only from the risk perspective for disabled people, but also under the aspect of accessibility. And many of this, you gave one example, doesn't work, and designers don't have it in mind. So what we think is that rules need to oblige AI designers to have special needs in mind in order to make it accessible from the beginning.
And just to add a little remark, this quite related to your question that is concerning the biometric data. I think that from the European perspective, there is no doubt that it is covered by the Article 9 of the General Data Regulation, Protection Regulation. That protection requires additional regulation at national law. That was the point that I tried to highlight. In the case of Spain, we have the case that I mentioned in my presentation, in which everybody is completely agreed, courts and agencies, that without additional regulation, it is not possible to use biometric data.
Dear colleagues, I have arguably ruthlessly abused my minute. Expected. I am advised that lunch may be available. I encourage you to go investigate. My understanding is that we will begin the following panel as scheduled, meaning you have less time than anticipated for lunch. I apologize with great enthusiasm. I encourage you to make the most of the time that you have. Thank you.
Okay. Good afternoon, everybody, and thank you to Oxford University for the opportunity for me to speak today. My name is Heather Benko, and I work for the American National Standards Institute. ANSI is the U.S. representative to ISO and IEC. We're the sole U.S. dues-paying representative to ISO and IEC. We also coordinate the U.S. Voluntary Consensus Standards and Conformity Assessment System. I mentioned ISO and IEC previously. Those are two non-treaty organizations developing international standards in a variety of areas. One of my main roles at ANSI is I'm the committee manager, which is kind of the program operator for the ISO IEC Joint Technical Committee on Artificial Intelligence in the areas of artificial intelligence. I say areas because it's not just one area, it's a variety of software and hardware areas. I would point out I am not a technical expert in the area of AI. I'm more of the process person, but I'm here to introduce our work and some work of relevance to the areas of risk. For those of you that may not be familiar with standards, I do want to give a little bit of background and identify some key terms, because I think there's often confusion between what's a standard and what's a regulation. Standards are market-driven product and service specifications. When I say standards, I'm talking about voluntary consensus standards. So these are not mandatory documents. They're developed in a open process, transparency. I would note that standards can, even though they are not regulation, they can be utilized in regulation, and they can be utilized in lieu of regulation. Where there's no current regulatory scheme, standards can provide globally accepted methods and guidance for organizations and companies to utilize. Regulations are different, obviously. They're developed by governments and they're mandatory. You don't really have a choice whether you utilize them or not. And then conformity assessment is something I will just briefly touch upon. And those are processes and systems used to verify the compliance of a product, person, process, or system. And they're usually against a standard or regulation. With regards to standards, I'm sure many of you have heard I'm ISO 9001 certified, or we're ISO 14001 certified. That means that organization is following the specific processes established in those standards. Just to provide a little bit of background on JTC1 SC42 on artificial intelligence. Again, we're part of the JTC1 family. JTC1 is the only joint committee between ISO and IEC. The focus is entirely on information technology. There's committees on JPEG, EdPEG, which I'm sure we're all familiar with. There's standards. There's a committee on security and cybersecurity and privacy. SC42 is one of the latest subcommittees in JTC1. There is a more recent one on brain-computer interface, which sounds very exciting, and I'm sure I would love to talk about that at some point in the future, but that's not my area of expertise. SC42, we were established at the end of 2017, so we're a fairly new committee, as I noted, about 5 years in establishment. And where our focus is developing horizontal standards in the areas of artificial intelligence. We do not do sector-specific standards. We develop general documents that we anticipate will be adopted and implemented by other ISO, IEC, JTC1 committees, or even external organizations when they're developing their AI-specific documents. So our goal is the widespread adoption and application of our documents in a variety of domains. At this point, we're very large. We have about 50 countries participating out of the 160 plus ISO, IEC committees that participate in those two activities. We have a work program that has grown from 2 initial projects to, I think we have 26 active projects now. That number may have just increased, and 12 published documents. The role of the national bodies that participate and our liaison organizations is to bring to our attention projects that need to be developed. We want the standards that come out of our committee to be industry relevant and globally utilized and needed within the community. So we're always looking for new areas of work that will benefit that work for the net benefit of the international community. Some of our recent areas of work, we have a management system standard on artificial intelligence, which I'll describe in a little bit later. We have extensive work on data quality, including data quality governance, explainability of AI, functional safety, unwanted bias, transparency, taxonomy. These are just some of our newer projects. We have a very extensive set of liaisons, both within and outside of ISO, IEC, and JTC1. And we have about 13 category A liaisons. I note that the European Commission is present on this panel today. The EC is a liaison organization and has engaged with us in the past and presented to us, and we have engaged in some of their activities. We are also engaged with the OECD and have participated in, actually the last time I traveled was February 2020 to the OECD's first AI meeting that they held in Paris, and then everything locked down. So that was a very exciting time. But the OECD is also engaged with us in this activity. We value these liaison relationships. Not only do we see them as collaborators, but we see them as our customers. collaborators in terms of we want them to come to our meetings, come to our discussions, provide their technical input, and identify what their needs are in terms of AI standards, but also our customers. We hope that they adopt and implement our standards in their various areas of work relative to artificial intelligence. I share this slide for a couple of reasons. One, it's not so wordy. Two, it gives a good visual representation of how much SC42 has grown in the time that we have been developing standards. Our first meeting, we had about 89 people. Our last meeting in person was in Tokyo, and that's in the top left-hand corner. And we had about 170 people present. So over the 5 years that we have been operating, we've had extensive growth. I would note, since we've gone virtually, we've had over 200 to 250 people participating. In terms of the current structure of SC42, we have 6 working groups at this point. One of them is joint, and then we have an advisory group. Our first working group is on foundational standards, and that looks at issues like our terminology and framework for machine learning document. And that's where we're also developing our management system standard. Our second working group is on data, and that's not focusing on just big data, but we're also looking at analytics and data quality. Our biggest working group, obviously, is trustworthiness to ensure the successful adoption of AI. People need to trust the AI systems that are being implemented. And that's where we have a lot of work relative to functional safety, controllability, risk management. Our fourth working group is on use cases and applications. This group has predominantly focused on the use case aspect. We've collected a large number of use cases. Our first document out of that particular group was a collection of the use cases. I think we had over 130 different use cases of AI in various industry sectors. I don't think it would be a surprise to anyone. I think the largest sector was the healthcare sector. That group was also looking at life cycle and guidelines for utilization of AI. Our fifth working group is computational approaches and characteristics, and that's looking at key industry agreed tenets for classification performance of AI systems. Our last working group is something called a joint working group. So often, while we develop horizontal standards in the areas of artificial intelligence, it's also necessary for us to collaborate on sector-specific projects. In this instance, we're collaborating with another JCC1 committee, which is looking at software and systems engineering. And we're developing a standard on testing for AI systems. And our third group, that our AG3, which I want to mention, is our landscaping and road mapping group. This group does not develop standards. What they do is they identify gaps in our work program, priority areas that we need to be working in, and potential future projects that we should be developing. So the nice thing about SC42 is we look at the entire AI ecosystem. As I mentioned before, AI is not a single technology, but it's a collection of technologies. But oftentimes the various stakeholders don't make that separation, that it's both hardware and software. They just see it as AI. And it's different from typical IT standards in a lot of ways, because the stakeholders are numerous, they're diverse, and they're not they're sometimes outside the norm. So we're dealing with social scientists, regulators, ethicists, and they're not just looking at deploying these systems, focusing on the technology capabilities, but on customer needs, regulatory requirements, and products. So while it's important to make sure we're getting the technology right, we also want to make sure we're getting the societal aspects right. We want to look at the ethical implications of utilizing these AI systems in an organization and company. Another difference for AI is that, AI is going to touch almost every industry sector that there is. And so there's a lot of collaboration that needs to take place across domains and in different application areas that have been kind of outside the normal IT realm. So it's a broad standardization approach that goes beyond traditional interoperability and traditional technical requirements. So we're not just looking at the technology itself, we're looking at the use of the technology, not only the technology capability, but the non-technical requirements, any business requirements, policy requirements, regulatory, and across those application domains, and translating those needs into the technical requirements. And again, we're developing horizontal standards that can be utilized across the community. We also provide a forum to bring all of those folks together to talk and to collaborate to develop standards in this area. So I did want to provide some examples of projects that SC42 is doing related to the topic of risk, which I know is a very big issue. I participated a couple of months ago. NIST had a workshop that they're putting together a risk management framework, and I presented on the work of SC42. I would note that all of these documents that I mentioned here, and most of the documents under development by SC42, can be utilized by organizations and companies of any size. We're not looking just at the big global companies, we're looking at the small startups as well. So our intention is the larger adoption of these documents by any organization. So I did previously mention our document on risk management that's under development now. It provides guidance to organizations. We don't have specific requirements or basis for certification that people can say, well, I'm certified against this particular document. And it's an organizational risk management document, but at the same time, we're looking at the impact of these systems on things like the individual, labor, and the environment. We are considering those as part of organizational risk management. I also mentioned our functional safety project. That is not only a functional safety approach to risk, but it's also looking at organizational risk. And we're looking at this to use of AI systems to design and develop safety related functions. Again, these are for organizations of any size. Two of the other projects I want to mention just briefly is our governance of IT, the implications of use of AI by organizations. This is one of those projects that we developed jointly with another committee, with another JTC1 committee, specifically on IT governance and IT service management. And really, this is for the decision makers. It's for the policy makers, it's for the managers, for the auditors, to enable and govern the use of AI within their respective organizations to ensure its efficiency, effectivity, and acceptable use. And then I want to briefly touch upon our management system standard, ISO 42001. This is under development. This is looking at the AI specific aspects of a management system standard. The benefit of an MSS is it's a specific process and order that people are required to follow. And it gives a certain amount of credibility if an organization says, I'm ISO 9000 certified. We hope the same thing will happen. I'm ISO 42001 certified. And just to touch upon a couple of our other documents that are of relevance and I think important, all of our documents are important, but just to focus on a few. Our terminology, AI context and terminology document, ISO 22989, ISO IEC 22989. This document establishes definitions for AI, even though a number of documents have already defined artificial intelligence. This is how SC42 is defining AI. AI systems, general AI. We anticipate this document to be utilized not only within SC42 and our liaisons, but hopefully external to the work of SC42 and our liaison relationships. Another important document that we have underway is objectives and approaches for explainability of AI, ML models and AI systems. We want the community to understand and what we're talking about. And this is an important aspect of that project. Our next one is treatment of an unwanted bias in classification and regression machine learning tasks. This is a newer project that we have underway to mitigate unwanted bias in AI systems. We had originally developed kind of a state-of-the-art paper on unwanted bias, and this new document that we have under development builds on that previous technical report. And the last project I want to mention is an overview of ethical and societal concerns relative to artificial intelligence. As I noted before, and I'm sure as you're all aware, living so close to Europe, ethics relative to AI is a very big topic and a very important topic. This document kind of provides an overview of the concerns that are there, some of the standards that can help mitigate those concerns. And many of them are developed within SC42, though not entirely. And I would note our complete work program can be found at the link below, and I'm happy to answer any questions when you have them. Thank you.
Can I was going to ask, can I confirm with the AV whether my microphone is working online? Because it looks like it may not be.
I can hear you.
Yeah, okay. Thank you so much, Heather. In that case, I'm going to introduce our second speaker today, who we're very fortunate to have with us in person. Jan Kleijsen is joining us from the Council of Europe, and he joined the Council of Europe in 1983 as a lawyer with the European Commission of Human Rights. Subsequently, he served in the Parliamentary Assembly and as director of the Secretary General's private office. He is currently Director of Information Society, Action Against Crime. And his directorate also carries out standard setting, also monitoring and cooperation activities on a wide variety of issues. And a selection of those issues are data protection, artificial intelligence, cybercrime, and internet governance. So thank you, Jan, for joining us today, and I'll hand over to you.
Thank you very much. Hope this microphone works. Good afternoon, everyone. Perhaps by way of introduction, let me say a few words about the Council of Europe, who we are, and then I'll get into what we do, especially, of course, with regard to artificial intelligence, what we have done and what is coming up. A few words about the Council of Europe, because it's often confused with our younger but much richer sister, the European Union. Yes, money isn't perhaps everything, but it counts for something. The Council of Europe is Europe's oldest international organization. It was established in 1949 by the likes of Winston Churchill, Konrad Adenauer, de Gasperi, and other eminent stateswomen and statesmen to prevent the horrors from World War II recurring. Horrors that sadly, as I speak, we see today. The colors I'm wearing are not purely coincidental. They're a tribute to our member state, Ukraine, which is at the moment the victim of an unprovoked aggression by the Russian Federation, and which led the Council of Europe to the unprecedented step of expelling one of its member states within a week after the Russian aggression. The Russian Federation, which at the time was our 47th member state, was suspended, and 3 weeks later, Russia was expelled from the Council of Europe, because membership of the Council of Europe requires a commitment to human rights and democracy. So there was no other way than to terminate Russia's membership. Sadly, of course, this also prevents 150 million Russian citizens from having access to the European Court of Human Rights and other treaty mechanisms of the Council of Europe, to which I'll come in a moment. I gave you the Holy Trinity of the organization. It was established, as I said, more than over 70 years ago. And we've tried to promote these values, human rights, rule of law, democracy, essentially through political and legal cooperation. That has led to over 200 treaties, conventions, as we call them in Strasbourg. Some of them you may have heard of, the European Convention on Human Rights with its court, which allows direct access by the citizen to lodge a complaint against a state party. And you don't have to be a citizen of the state. to a state party to that convention. We have the Convention Against Torture. We have a social charter, and increasingly our conventions have become open conventions, not limited to member states, and that is important with regard to the field of technology in general, and also artificial intelligence in particular. It became evident already at an early stage, over 40 years ago, that technological developments were having an impact on our fundamental rights, which is why 41 years ago, everything okay? Yeah. Why 41 years ago, the Council of Europe established the Data Protection Convention at a time when virtually no country in the world had any data protection legislation worthy of the name. It was a truly pioneering legal instrument, as we call it, a pioneering convention. It directly inspired the GDPR. GDPR is directly inspired by Convention 108, as it's called. In the light of GDPR, the convention itself was modernized. So we, with the European Union, all of whose members, by the way, are member states also of the Council of Europe, the Convention 108 was modernized. And some 21 years ago, the Council of Europe established the world's first treaty on cybercrime. Again, because it was evident that with the growth of the internet, with digital developments, online crime, crime in cyberspace was becoming an issue. It was originally defined as crime committed through computer systems, and later through agreement by the parties, guidance notes. That means every device, including smartphones, that can access the internet and provide for digital communication. I'm mentioning these two conventions because the Data Protection Convention now has 55 state parties, and we were active in more than 70 countries last year. So nearly, that's for data protection. For cybercrime, we're even more global. We have 66 state parties and about 4 or 5 in the pipeline, which we expect to join this year. And last year, the Council of Europe worked in 130 countries across the world. So well beyond the borders of Europe. And this is important also with regard to AI, and I come to this in a moment. I should also point out, since this is a truly international audience, that we have parties to the Cybercrime Convention on all 5 continents. We have African countries, South American countries, Central American countries, Asian countries, Southeast Asian countries, Asian Pacific parties. So it's really a global treaty. It became evident that another technological development, and now I turn to artificial intelligence, was beginning to have an impact on freedoms, individual freedoms, but also on the rule of law and democracy a couple of years ago. A number of cases emerged, and many of you will be familiar with experimental use of artificial intelligence, for instance, in the justice system. In the criminal justice system, a number of US states experimented with parole boards using artificial intelligence with normally, I must say here, quite disastrous circumstances, quite disastrous consequences. And that led the member states of the Council of Europe to start thinking about whether it was necessary to develop specific standards for the use of artificial intelligence, for the development of artificial intelligence, with regard to human rights and rule of law. The aim was never, still isn't, to regulate the technology. Of course, the technology brings enormous benefits, as most technologies do. So we are certainly not standing in the way of innovation, as some have argued, but are very much concerned that the development and the use, and especially, of course, the use by public authorities, by the state, of artificial intelligence has an impact on human rights. Because, of course, you can change your service provider, you can go to another customer, you could change your nationality, but it's a lot more difficult. So when the state uses these systems, as citizens, I think we all have a particular interest that standards are being applied, because the options, the chances or possibilities to opt out are very limited indeed. I'll summarize a bit because I could go more into detail, but to tell you what has happened in the past 2 years is that on the basis of all the ethical charters and ethical guidelines that began to circulate and which were very interesting, still are very interesting, but have a few shortcomings. Major shortcomings, of course, are only as good as the implementation by the owners of the ethical charter. And we have seen dramatic examples by big companies blatantly disregarding their own ethical charters. It doesn't provide you as a citizen with any protection. You can't go to court and say, but the ethical charter says this. It doesn't provide a remedy, and it, of course, doesn't bind the state authorities. So our member states set up a group of experts, which we call the CAHI. I'm saying this in case you might want to look it up. And it put 2 questions to this group. The first question was, are we in need of further regulation? Since the title is The Race to Regulate here, is further regulation necessary with regard to AI? When it comes, again, from our specific Council of Europe angle, with regard to human rights, rule of law and democracy. Do we need anything more? Because we have a number of treaties. I mentioned the European Convention on Human Rights, the Cybercrime Convention, the Data Protection Convention. We have a convention for the protection of children against abuse, also online abuse, and so on. As I said, we have 200 of them altogether. So there's a lot of stuff out there. We know national authorities have adopted laws. Some countries have been quite active, but is that enough? And the second question, that was the first question. And the second question was, if that is not enough, could you please, dear experts, identify the elements of a new convention, a new legal framework that would complement, that would fill the gaps that you would have identified? In other words, can you please look at the ingredients for the dish? Don't start cooking it yet, but see what ingredients you would need for a future instrument. The committee was set up in a particular way. I'd like to underline that here. It was, as will not surprise you, made up of the then 47 state representative countries that made up the Council of Europe, which was a bit of a nightmare trying to get the right ministries, by the way, because when we negotiate a treaty on criminal law, it's usually quite simple because we get the criminal law experts and they usually come from the Ministry of Justice. Or when we have social rights, the ministries are also usually well defined. It turned out with regard to artificial intelligence that virtually no country had a single point of contact. And that there was a variety of ministries being involved, and they still are, and that poses some problems I'll come to, if I'm allowed, at the end of my presentation. So we had the state representatives, then we had our observer states. We have the United States, Mexico, Japan, Canada, the Holy See, who are fully entitled to negotiate treaties with us. And in fact, the Cybercrime Convention, I mentioned, and I say this with a wink to the US participants at this meeting, was very much co-drafted by the United States, which enabled the proposal at the time by the State Department that the United States ratify this treaty to go through Congress, because it was seen, quite rightly so, as also a US negotiated product, not something imposed by some silly Europeans. So, and of course, the product benefited from this approach. I said we also have Mexico, so we have a South American perspective, we have Japan, there's an Asian perspective. In addition to that, we have representatives from civil society, very important in our work in the Council of Europe. We've had them since our very beginning. And since 5 years, we have a digital partnership with business. We have all the big Americans, the Meta, the Google, the Microsoft, etc. And we have a whole series of smaller companies and also standard setters. We have IEEE, for instance, with us. And this week we were joined by our 27th business partner, the Lego Group. Just to give you an idea of the variety of companies that we have telecoms as well, and associations of small European service providers. So they're all at the table. To now go a bit faster, at the end of 2020, despite the pandemic, which meant online meetings, this committee came to the conclusion unanimously that there were important gaps with regard to the protection of fundamental rights and the development and use of artificial intelligence. So that was a very important conclusion. As a result, the committee was asked to proceed with answering the second question, namely to identify the elements that should go into a future treaty. And those elements were presented to our governments by the end of 2021. So about 7-8 months ago. Since then, there has been a rather dramatic, there have been examples of why it is necessary to do something about AI and why the race is actually necessary. And I would argue here quite strongly, we're not racing fast enough. We're walking, we should be running. I happen to enjoy marathon running. People may think I'm a masochist, but in this case, I think it is running that is required. And perhaps we shouldn't run even at a marathon pace. I think we should probably run at a sprint pace. In my own country, sadly, I'm Dutch, as you will have gathered from my accent and my name, a major scandal has erupted, which has led to the loss of human life, to the fall of the government, to the president of our highest administrative court publicly apologizing on television for miscarriage of justice. Nearly 1,700 children that were taken away from their families and still have not been returned to the families. In total, and I checked the latest figures just before speaking at lunchtime, there are nearly 50,000 certified victims of this. And what happened, and I'll give you a very short summary, is that the Dutch tax authorities, in order to fight against fraud, decided to use technology, artificial intelligence, algorithms, to help identify those who were abusing the child benefits, family allowances. And as it turned out, the system was, everything that could possibly go wrong went wrong. The system was highly biased. It turns out now, and this was a study, there were some details that actually just came out 2-3 weeks ago. And if you're interested, you can find it on my Twitter feed. The Dutch NGO actually dissected the algorithms that were used and the parameters used and came to the conclusion that highly racist elements were included. Being of non-Dutch origin immediately put you up 10 notches on the suspected fraud scale. The fact that you didn't master the Dutch language properly, that you didn't have a university degree, that you lived in a certain neighborhood, all of this was held against you and led to a profile, a fraud profile, on the basis of which very dramatic decisions were taken, because thousands of people were forced to pay back the benefits they had received. And we're here speaking about people on very low income who were forced to pay back huge amounts of money. A number of people committed suicide. I mean, there was loss of life. Many families were destroyed. Livelihoods were destroyed. I say I'm speaking about 50,000 people, and the Netherlands has 17 million inhabitants, so we're not a very big country. But I would gather that for most countries, 50,000 people and nearly 1,700 children being taken away because of basically wrong, a highly biased automated decision-making system would be dramatic. The Dutch Parliament adopted a report, which you can also find now. It's been translated into English, I think, very usefully. It's called Unprecedented Injustice, which I think is a very apt title for what happened. And the Dutch Parliament also requested the Council of Europe to give an opinion on this situation. It was done by a Council of Europe advisory body, which is called the Venice Commission, because it has its seat in Venice, it meets in Venice. The Venice Commission adopted a report in October 21 and drew attention to the problems with the governance of this automated decision-making. It interestingly pointed out that this happened in the Netherlands, but could easily have happened and is likely to happen elsewhere if we don't, as I say, if we don't race fast enough, if we don't actually come up with some binding regulation fairly quickly. Because the temptation, of course, to use automated system, and that was certainly the case in the Netherlands, is enormous. It's very tempting. I mean, you have a lot of companies that push products saying, I mean, look at these wonderful opportunities. You want to fight fraud? We will help you to fight fraud very efficiently. What happened with the Dutch judiciary was, and I will summarize it, is that the computer said it was okay. One of the major shortcomings, and this again, the Venice Commission points out, it happened in the Netherlands, but could also, and is likely to happen elsewhere, is the belief, the faith in the infallibility and the objective analysis by a computer system. So who was the human judge to challenge what a computer system, an AI system at that, had come up with? So the courts only dismissed the complaints and did not go into the merits of the issues that were raised. I'm telling this a slightly longer story, not because it happens to be my own country. I'm of course very embarrassed about what happened, but it is something that is a lesson, I think, should be a lesson to us all. This can happen elsewhere, is probably happening elsewhere as we speak, and with new AI models and new AI technology being developed. Well, you're probably much more aware than I am, most of you, about the possibilities of the foundation models of new AI technology, GPT, general purpose technology models that can be used for a variety of purposes. Temptation will be enormous for states, actors to use it, especially in times, of course, of economic crisis, because it's going to be a lot cheaper than employing lots of civil servants. So you can delegate it to the system. So extremely important that there will be safeguards to do so. We have now received a mandate following this double answer. Yes, there are gaps, and yes, we have identified a number of elements. We have the ingredients for the dish. We've now been asked to start cooking it. We have started negotiating. We've been given a very short deadline by September 23. So that is, if you take the summer holidays, we basically have a year to find agreement amongst 54 states, 28 major companies, 27 major companies, a lot of NGOs, on what I hope will be the world's first binding treaty on AI, which should introduce a number of safeguards. These safeguards should give rights to the citizen. And I think I'm sure there will be a question already looming, what's the difference with the AI Act of the European Union? One of the differences is that they're complementary, let me say that. We will have a lot of things in common. We speak to each other, we go to each other's meetings, but the AI Act is about the internal market. It is true the European Parliament is pushing very hard also for fundamental rights safeguards, but the origin of the Commission's proposal is internal market. Our origin is human rights. It should be a human rights treaty. So there should be rights for the citizen. There should be remedies. If it goes wrong, it should not be left to the mere statement that the computer said it was okay. Well, perhaps the computer may have said so, but the computer can bloody well get it wrong, as was demonstrated. So there should be oversight. There should be meaningful human oversight. There should be a final decision by a human. There should be the possibility, there should be the obligation, not the possibility, the obligation that the citizen is informed. The citizen must be informed if she or he is subject to an AI, to an automated system, and not dealing with a human agent. Examples this morning, very interesting, were given of very advanced California state law in the US on the obligation to inform customers. In our case, it's obligation to inform the citizen. Transparency, we're asking for oversight bodies in the first draft, in the elements that you will find, and it's all publicly accessible, this is what I mentioned. Non-discrimination is very, very important. We also strongly believe that human rights should be there from the design phase, from the very beginning. It should not be an afterthought. Systems should not be put on the market and then suddenly someone should say, oh, by the way, yes, we should think about human rights. No, it should be there right from the beginning. Human rights, you know the expression, no doubt, privacy by design. With regard to data protection, we strongly believe you should have human rights by design when you start developing AI systems. In the elements, we have also included the notion of an environmental impact assessment, because you all know, again, better than I do, I'm a mere lawyer, but the technicians under you will know that the carbon footprint of training AI models can be huge. So a question that should be asked, is it at all necessary to do this for some cases, just to get a very minor increase in accuracy? Is that very minor increase in accuracy, does that justify the enormous expenditure and the enormous energy that will be used for the training of a particular system? Think very hard for which purposes you want it. Then there are red lines. There will also be in a treaty. One which seems to have command agreement at the moment is emotional recognition. This is something that none of our governments seems to want, and I think quite rightly so. On other red lines, so it's the general use of facial recognition. There are a variety of opinions. What in any case we hope will come out is that if facial recognition is to be allowed, if there's no absolute ban, that it will be subject to very strict safeguards and judicial control and very strict purpose limitations. From the design phase, we also, of course, would promote inclusiveness, and I will stop in a few moments, I think. Yes, thank you. I see the man with the almost orange scarf and my my national colors coming up. Okay, I'll draw to an end. Where will we go now? We will hopefully negotiate this treaty in the coming year. There will be certainly the possibility at some point we will reach out to the public more at large to make comments via the NGOs, but probably also in other ways. We very much hope that other states will join. Something I forgot to mention is that the government of Israel requested to be admitted to doing already to the identification phase and is now negotiating at its request. Australia has just reached, we have just received a request from Australia, whether it could join. So that is extremely interesting for us. I've been in touch with the Minister of Justice of Colombia, who are interested in joining. So we're trying to reach out to a number of governments in the world, because it is my sincere hope and also belief that we need international standards. We need binding standards, and the more global the standards are that we develop, the better it is. The better is it for the citizen, for citizens around the world. The better it is, of course, also, by the way, for business, because you create a level playing field. There will be actors in the world that will not accede to this treaty, at least not immediately, but we hope that, like the Cybercrime Convention, it will impose what we hope is a global gold standard, a good standard for ethical and decent behavior with regard to development and regulation of AI. Could go on for another 2 hours, but I'll stop here. Thank you so much.
Thank you so much, Jan. We're now turning back online to Audrey, who hopefully will join us momentarily. Audrey Plonk is head of the Digital Economy Policy Division of the Directorate for Science, Technology and Innovation at the OECD. As head of division, Ms. Plonk contributes to the development of evidence-based policies through multi-stakeholder processes to stimulate the growth of an accessible, innovative, open, inclusive and trustworthy digital economy for sustained prosperity and well-being, and also to provide policymakers with the tools needed to develop a forward-looking, whole-of-government policy response that leverages the potential of digitalization for growth and well-being. So from the OECD, we have Audrey.
Thank you so much. It's great to be with you today. I'm sorry I couldn't be there in person. But the technology is so great that it makes it possible to be with you anyway. So I'm happy to talk about the work of the OECD with regard to artificial intelligence, but maybe let me start first by just saying that the OECD is an international organization comprised of 38 member states, all of which are market-based democracies that work together on a variety of issues, including basically every issue you can find in an economy. And sort of the unique feature of the OECD is that we basically mirror an entire economy here under one roof. So a lot of the value added comes from cross collaboration across different communities and different sets of expertise and sectors. And that's certainly been the case with our work on AI. We have a long history of working on science and technology and innovation at the OECD. It dates back to the genesis of the organization, which, similar to the Council of Europe, came out of the Second World War, and it's evolved over time, of course. But some of the early work we've done in the last 40 years on topics like privacy, later on cybersecurity, and others have formed a foundation that we draw on for our work on artificial intelligence. So just sort of moving specifically to AI, we developed a set of principles, and I know everyone has principles now, but we developed the first intergovernmental standard on artificial intelligence that was adopted by OECD countries back in 2019, and it was developed through a broad multi-stakeholder process that focused on academia, private sector, non-governmental organizations, civil society, what we call the technical community, as well as obviously our governments, our member countries. And this document did a few things. The first is that it defined artificial intelligence in a way that was, I think, is well recognized and is a solid definition on which to build. The second thing it did is it laid out 5 value-based principles, and those principles are based on human autonomy, fairness, accountability, trustworthiness, sort of all the main themes you expect to see these days in AI work, but they're detailed out in a slightly different way and through the lens of promoting the technology, but in a responsible and trustworthy way. And then there's the third thing it did is it set out a set of 5 policy areas for governments to work on collaboratively, including investment in research and development, including creating an enabling policy environment to advance AI, working together in a cross-border way. And since the adoption of those principles in 2019, we've really accelerated what we think of as implementation. And because we believe it's really important to have principles, but as my colleague from the Council of Europe said, they're only as good as they are implemented. And so the big difference between the OECD and other organizations is we're very much an evidence-based policy-making organization. So we gather data, we analyze data, and we try to do empirical analysis to help countries build policy based on a strong evidence base. So at a high level, that's what we've been doing the past few years since the principles were adopted in a few different ways. And I'll touch on it very briefly because I know we really want to have a discussion. The first is that we launched an observatory, what we call OECD.ai. That's the URL you can go to. And it's a sort of one-of-a-kind place for looking at what's happening in AI globally. We have a few different aspects of that platform, but the ones that are probably the most interesting are the database of country initiatives, which includes over 600 initiatives across more than 70 countries. So it goes well beyond the OECD membership. And those initiatives map to the principles. So we try to look at, within the concept of trustworthiness or in the concept of accountability or the concept of traceability, what are countries doing in that? So again, we're about getting information into the hands of both the research community, academia, but also government policymakers who can look at across countries and share information with each other, learn from each other, and ultimately look at sort of what's working. The second sort of area that we look at is data from sources that we're partnering with. So we have data visualizations based on a large series of data sets that includes looking at patent data. We look at research collaboration data, research publication data at a cross-country comparable level. We look at jobs data. We look at other aspects of research. And so there's a lot of data visualizations on the platform where you can look at how countries are working together, where research is coming from, where investment from venture capital into AI is going. So a sort of wide range of countries or policymakers want to look at sort of what's happening in a certain aspect of the economy around AI. They can go look at data. It's updated very, very regularly, unlike a lot of statistical work. We have partnerships with data sources that allow us to get more readily more real-time, if you will, access to data. And then we have, of course, the work of the OECD itself, in partnership with other committees, and you can see some of the analysis we've done with regard to things like productivity and jobs and skills that are available on the platform. And then we have some fun things like blogs and the experts group that we run that includes more than 200 people to continue to develop our work. So that's one thing we started doing in terms of implementing this principles of looking at how do we take these concepts and put some data and information behind them so that policymakers can get a sense of what's happening out there. The second thing we started to do is build a framework for classifying AI systems. And what that basically means is we started down the path of trying to get to build a model whereby governments could start to speak the same language around what is a system doing, what is an AI implementation doing. And I like to think that if something like this had been available, perhaps when the Dutch government were implementing their AI algorithms, they might have paused and stopped and said, perhaps the impact here is high and we need to look at this. And so that's the classification framework is public now. It went through a development process of over a year and a very, very broad public consultation process that we got thousands and thousands of comments. And so the model basically looks at the context, so the external environment in which the data are, where whatever is coming into the AI system. So the context looks at data as an input. It looks at the system, so the algorithms itself and the computing behind it. And then it looks at the output and the output. So it sort of breaks the sort of broad umbrella of AI down into these components. And the framework walks through a series of questions to get at an understanding of what the system is ultimately doing. And eventually, we hope that based on understanding what the system is doing, we can start to classify risk, as we see much of the regulation and policy attempts around the world are based on this concept of risk. Of course, it's a really common concept in everything we do. And so the question of how do we assess that risk, and how do we assess it in a way that's somewhat coherent at an international level, because while we'll have different concepts of risk in different cultures, if we're not speaking somewhat the same language, or at least we're not, sort of thinking of the systems and in the same way, it won't necessarily advance the common good. So that framework is out, and we're modeling it with lots of different partners, including research institutes around the world, and it will be an improved, something that we continue to improve over time with our experts group. A couple other things that we're working on in terms of implementation that are probably of interest to this group is the development of an incidents database. So we're starting to look at AI incidents. So this was teed up nicely for me by Jan, talking about the now very infamous situation in the Netherlands. But we want to build a picture of what's happening with incidents around AI. We're in early phases of doing that, using public media reports at the moment, but and scraping that data and analyzing it. And we're actually training an algorithm to analyze the data and looking at the success rates of positive identification of an AI incident versus something that may be less. And we can talk about that more. And then we're also really interested in computing resources and availability of computing resources at the national level. In addition to looking at, of course, the risk and harm of AI, we're also looking at the benefit and how to get benefit from it, how to make it more equally accessible and applicable across countries at a national and cross-border level. And we see a lot of concentration, of course, in certain big economies. And so one of the factors there is the access to computing power. And so we have a task force that's looking at that. And we're building a sort of understanding. We have a lot of other work looking specifically at natural language processing aspects of AI and other a little bit more in the weeds stuff that I won't get into too much. But I guess I'll close by just saying that what we observe is there's a lot of really important initiatives. You've heard about what the Council of Europe is doing. There's the AI Act in the EU. There's the standardization efforts in ISO, as well as national level standardization efforts. There's principles efforts and guidelines and a lot of effort out there that is well placed and extremely important. And I think we see an important role for not just the OECD, but for as a collective community, for us to try to connect some of these broad concepts of things like risk and things like harm, and how do we define those, to things that are perhaps more implementable and actionable, at an actual technology level. We're a policy organization, so we're not necessarily always the right people to do that, but we try to sort of serve as the glue between some of the high level ambition that policy has and the ability to actually practically implement it in some of these, both either in policy environments or in technology itself. And so I completely agree with my colleagues. We're at the beginning of a journey that is extremely important, and we need to continue to move fast, maybe move faster, but also recognize we will evolve over time, and there probably isn't really an endpoint. It's a long-term governing aspect of things. So thanks again for having me. I look forward to the discussion.
Thank you so much, Audrey. Thank you, Audrey. So joining us for discussion to bring together some of these points is Chinmay Arun. Chinmay is currently a resident fellow of the Yale Information Society project, but I believe the news has just broken that Chinmay is also the new executive director of the ISP. So huge congratulations to Chinmay.
Thank you. Thank you.
In the past, she has served on the faculties of two of the most highly regarded law schools in India, and was also the founder of the director of the Center for Communication Governance at National Law University, Delhi. She was a fellow of the Berkman Klein Center of Internet and Society at Harvard University from 2017 to 2019, and has been a human rights officer with the UN, and also remains a member of the UN Global Pulse Advisory Group on the governance of data and AI. Her recent writing has focused on the impact of AI and algorithms on human rights in the global south. Thank you, Chinmay.
Thank you. It's such an honor to be a part of this conference session, and I only wish that I could be there in person. I've learned so much from listening to the three panelists, and I'm going to respond to the things that they're saying from my point of view, which is typically that as we're thinking through detailed globalized standards, how are people in what I think of as the majority world, people call it the global south, and before that they called it the developing world or the third world, how are they affected as the world tries to think about these problems and works out ways to respond to them? And I think that each of the panelists has offered both very rich perspectives that kind of take into account the moving and tentative nature of the creation of these standards and the challenges in getting different stakeholders from across the world on board. And I want to acknowledge that and say that I'm probably going to go back and read more thanks to the things that you've told me. From what I'm hearing, there's actually great work being done on principles, given the amount of information that's out there, given the pushback to regulation. It's impressive that all three of you work with organizations that have soldiered forward and that have made attempts in different ways to help us think about how to regulate AI. But that said, I think that all of us are aware that rules and standards that work in one context don't necessarily work in another. And that, as all of you have highlighted, moving towards standardization and towards international regulatory coordination can be a challenge, both in terms of understanding how people in different contexts are affected, but also in terms of working out, even in a multi-stakeholder consultative process, how to access the information that you need to come up with effective regulation, and to ensure that it is articulated in a way in which it is legible to the debate that you're having. So in other words, there's two kinds of power to take into account here. There is internal power within a state of social groups. So for example, the dominant social group might not be affected by the use of algorithmic systems the way in which a less dominant social group, say refugees, or a group facing historic discrimination would be affected. And then when the participation in an international debate takes place, the question, then it's a different kind of power, right? Because this is a global conversation that has to be articulated in a particular way for the process to recognize that concerns are being voiced. And so there's a country level challenge of how does a group that doesn't have power in the first place communicate with its representatives that they need to be represented at the international debate. And then there's a second level of how do you articulate the problem in the international debate in ways that it is heard and acknowledged. And I think that that takes place in any system in which international coordination is taking place. And then, of course, the progression is gradual. And so we are in a place in which we are discussing the future of work, which is very important, while the present of work remains unequal. If you think about different labor laws around the world, and you think about the people that even in countries that we would consider very progressive are outside of the operation of labor laws for various reasons, you'll see that there's a lot of work to be done, both on the old principles and on ensuring that the new principles are alive to these challenges. And I'm encouraged by the fact that I think all of you acknowledge that this is the case. I think the other question that I would like to draw out is the one that Mr. Claesen so effectively highlighted, which is that AI is not just about commercial products and about the purely privatized sector. There is a public component to it, and increasingly we're in a situation in which AI is beginning to intermediate the relationship between states and citizens. And again, going back to the things that I was saying before, I think that is so important. And I'm so glad that it was brought up, because states tend to be most territorial about their relationships with their citizens. And when they start adopting AI systems to sort of act as a go-between in how citizens access their rights, there's very little that can usually be done to ensure that they don't. And I think that that is a big challenge for coordinated regulation, however well-intentioned and however principled. Let me give you an example. In addition to the powerful Dutch story that we just heard, you are, I think, aware that these systems are used to create databases of citizens who are then given access to benefits or not, depending on, firstly, whether they are acknowledged in the database as citizens at all, and then secondly, based on how they are acknowledged in the database. And so that's interesting, because that is a level at which your identity as a citizen is now almost entirely dependent on how it is reflected within this system. And if you do not have the power to have a mistake corrected, then you are in a position in which, although you are technically a citizen and technically entitled to rights, the intermediate sort of computer-based system is now serving as the truth in place of what you say. And I think that these are very real challenges that we have to cope with, and challenges that are amplified depending on which part of the world people are from and which social group that they belong to. I think the last thing that I want to leave you with is that Ms. Blanc's very powerful presentation is also a story of how we think of these problems. Classification is very important, and classification also embeds the way in which we think of particular rights or not. And again, so if you think of data rights, for example, as rights that affect only individuals, you will regulate it in a particular way. Advocacy around it will be framed to protect individuals. On the other hand, if you read, for example, Professor Floridi's work and conceive of it as group rights, then advocacy around it and regulation around it will be framed differently. And so just to say that what each of you is doing is really valuable work. I'm glad that you're being so thoughtful about it. And thank you for the wonderful presentations. I think that this session gives us all a lot to think about. It certainly gives me a lot to think about. Thank you so much.
Thank you all so much. I think if we can get all of the speakers up as a gallery view, that would be ideal. Thank you. So I think we'll take an extra 10 minutes. I know we're a little bit over time, but just to get some questions. And I'll maybe kick off with one. And I think what we've understood from all four presentations is how important transnational standards are because of the international nature of the challenge, but also because, as Audrey mentioned, we need an international understanding of risk, at least a baseline understanding. But what we also heard is that it's very important to get the principles translated into practice. So as Jan mentioned, the Council of Europe is pushing for a binding treaty. But at the same time, we've seen how important it has been to have a judicial body on the European Convention of Human Rights, how helpful that has been. Similarly, we've seen with the OECD general principle or guiding principles for multinational enterprises that having the national contact point system has been very important and has given kind of new life to the UN guiding principles. And as was mentioned in relation to the ISO standards by Heather, the credibility from compliance has been really important in getting those kind of into practice. So I was wondering whether any of you have any thoughts on how these kind of transnational approaches can get into practice, perhaps via state law, or perhaps via the omnibus laws that we're going to hear about in the next session. I know, Jan, you mentioned the interplay between the Council of Europe's approaches and the EU's approaches. Perhaps you'd like to start off by thinking about how your human rights approach is influencing the EU, maybe.
Yes, thanks very much, and also my thanks, of course, to the other panelists and their insights. Very briefly, I think it's incredibly important that we are singing from the same hymn sheet, to use a popular British expression. I think that we are really, although getting perhaps a bit outdated these days, but that we're really working in tandem. It's that has to do with issues like definition, for instance, of scope. Something that Audrey hinted at. We have a common website with the OECD, with the World Bank, with the European Commission. There's a common website, Global AI something. Audrey, please help me. Where we pull our
globalpolicy.ai.
Sorry, we pool our information, so the various stages, and I think that is important. We participate in each other's work. I think it's also very important that this should not be seen just as a Western or a European-centered approach. That's why I insisted so much on our cybercrime convention with states from 5 continents very actively, and that convention has developed over the years thanks to the input from representatives from the 5 continents. So very much also have the Global South there. And I think also, of course, for a future AI treaty, it's extremely important that the Global South, as other regions, is duly represented.
Yeah, I want to make sure we get voices from the room. So I'll start with some questions. Christina, would you like to begin? Thank you.
Thanks so much. So I hear a lot of the talk about bringing the citizens' voice, bringing the Global South in, which I totally agree. Yet, Audrey, you know, I'm in the OECD AI1 expert group, was part of the group who drafted their principles, and I've also done work in standardization in IEEE. Now, Heather, this is a question to you, but also Audrey. How do we ensure democracy within your organizations? Heather, there's not any, I don't believe, worker representatives in the ISO working groups on artificial intelligence. Audrey, within the OECD AI1, it's very industry-led, very industry-dominated. So I'm sitting here thinking, I want and wish that we could be more diverse in setting these standards, which politically we can see the G7, the EU, US trade talks, the EU AI Act seem to be leaning towards, dare I say, the privatization of regulation through certifications and standards of a kind which I find dangerous if it's not inclusive of diverse voices, and for those I represent, that would be the workers.
So thank you for your question, and I certainly appreciate the concern that you have. I would say in terms of JTC1 SC42 and the development of standards, particularly you're focusing on labor, I'll focus on our management system standard, which does have a direct impact on labor. We actually have, as I mentioned, we have a number of liaison organizations that are internal to ISO, IEC, JTC1, and external organizations, including the ETUC, which deals with labor. And those representatives have been very heavily engaged in the development of a number of our documents, including the MSF. When national bodies come together to form national committees to respond to an ISO, IEC, or JTC1 group, their stakeholders are from a variety of interests, whether it's government, industry, NGOs, academics. At the national committee level, all of those people are responsible for coming together and forming a national position that gets put forward. And we often encourage, I know within the US, we often encourage engagement with consumer organizations, labor organizations, and they are engaged in a number of the national committees. Do I know specific names off the top of my head? I don't. A number of our working groups are quite large, but there are experts from all of those backgrounds, and we certainly do encourage that. We also have at the SC42 level engagement from Consumers International, because that is also a major group that's going to be impacted by artificial intelligence. Consumers are buying products that utilize AI already, and they may not understand the background of how they're being created. So we want those voices, and we do encourage those voices to actively participate and provide input. In terms of the general public, the way that, and I'll just speak from the US because I'm a US person. Within the US, we have a system from ANSI, it's called ANSI Standards Action, and it's a freely available publication that we publish weekly that lists all of the ISO, IEC standards that are at the, it's called DIS, Draft International Standard Balloting. Those are freely available. If someone has a comment that they would like to submit, it doesn't matter if you're from industry or academia or from the AFL-CIO, you can look at the document and provide your input, and that input is provided to the US group, which formulates the position that gets put forward. So I do understand your frustration that you can't see everybody that's engaged, but we do encourage through our liaisons like the ETUC, through Consumers International, to become engaged in the process at their national committee level and participate through a liaison organization. I would like to point out, there was a mention about the fact that, yes, this seems like a very Western-centric group. To Chinmay's point, we do have large active participation from India in SC42. They are leading a number of our projects, and we value the input from those countries that maybe aren't always well represented on panels and conferences like this, because we need that global perspective.
Thank you, Heather. I think perhaps we can have a short response from Audrey, if you'd like to give one, and then we'll take 2 final questions from the audience. Audrey, would you like to give any perspective from the OECD?
Yeah, so let me just say, I mean, we do this in a couple ways. We obviously have membership from Asia, from Europe, from North America, and from South America. The purpose for the OECD of having an experts group like our One AI group is to bring in voices beyond the governments, and so it sort of is by design inclusive of it has a bunch of non-governmental voices. I would argue we have a lot of civil society and academia participating there, not just industry. So there's some structural ways that we do this. We also have core stakeholder communities at the OECD that have an official role in our work. They don't vote like countries, but they have a seat at the table in our meetings. And those entities are civil society, what we call the technical community. I won't bother you with who that includes. Business, as well as the labor unions and whatnot. So we have various institutionalized ways. I mean, I'll say, and then of course in our AI work, we work with a bunch of non-member countries that are not part of not official members of the OECD, but who participate in our work. I guess I would say, another way of also looking at it is there's a lot of desire in sort of democratic rule of law societies to be setting standards. And there's a lot of tension between that model and how AI is used with sort of models of governance that are perhaps more oppressive or more restrictive or more autocratic. And so I think you see that countries like Europe and OECD countries wanting to work together to set very high standards for how technology is used, and feeling like they struggle to maybe work with some different, countries that have very, very different governing styles. So it's a tricky situation. I expect that will get geopolitically more complex as we move through time, which isn't to say that we shouldn't engage as broadly as possible, but just to say there are a lot of sensitivities around how these technologies are used, particularly with regard to human rights and speech and other topics. And so we have to navigate those complexities fairly astutely. So I'll leave it at that. Thank you.
Thank you, Audrey. I'll take two more questions together and then we can have perhaps very brief responses and get a break for coffee. One from Johanna. Johanna, did you? And then, yeah, and then one from you. Thank you.
Thank you. You actually asked the first half of my question, and the second half is enforcement of these standards. I mean, Jan said we need binding legal standards, and that's what I think is especially true for the world of work, but not only. And we're very critical with this private standardization processes to be used. Actually, I don't know which color of washing it is in the field of AI, greenwashing, whitewashing, whatever, saying that there are standards and that there's a concept for ethical AI when it's actually not applied and not enforceable. And so the question is, how can these standards be enforced? How are they enforced? Maybe so far.
And we had one more question.
Yes, thank you for all your terrific presentations. I had a related question, which is for the draft legislation being considered by the European Parliament or the Council, what do you believe is the correct relationship between the legislative activities and the standards? So should the legislation mandate using specific standards? And if so, should they be those developed by international bodies like the International Standards Organizations, or should they be government standards bodies such as the National Institute of Standards and Technology in the US or CENELAC in the European Union? Thanks.
Thank you so much. So on the first question, would you like to start, Jan? Or
yes, well, slightly. The lady there, I understand, that was the first to raise her hand after my presentation. So I don't know whether you want to. No. To ensure that the regulation is binding. I met, actually, interesting enough, with a representative of the European Parliament the other day who said, yeah, but we're working regulation, you're working on a treaty, that's not law. Well, it is. The moment the trade conventions of the Council of Europe are signed, there's an obligation on the governments to ensure that national law is in conformity. That's very much the case for the Cybercrime Convention. That was the case for the Data Protection Convention, the case for all our treaties. To give you an example, grooming was introduced as a term in the Convention Against Sexual Abuse of Children and has since made its way into the criminal law legislations of most countries that acceded to this. So when we negotiate something, there is an obligation for the state to ensure that the standards are how to put it, transposed into national law, and there will be a treaty body that will supervise this. All our conventions have at least a treaty body. Some have a court. Well, one has a court of human rights. We have also specific monitoring bodies. We'll see at what level we can pitch it, but there will certainly at least be a committee of the parties that will facilitate and it will ensure that the treaty is applied. Now, as to the standards that are being used, that is still open for discussion. We have IEEE, for instance, as one of our 27 business partners at the table, and they have made strong representations. We have at the Council of Europe something that few people will know, the European Pharmacopoeia. The quality of medicine in Europe is guaranteed by the Council of Europe. In other words, the aspirin you'll buy in the UK or in Oslo or in Istanbul is the same. It's the same ingredients. We test that. We have a laboratory to ensure to do that. And that's a public-private partnership, if you like. So with the standards, we have to see how they're defined. An annex to our treaty will be the human rights impact assessment methodology. It's already out there. It will be refined, which is a methodology to ensure that governments put the right questions, and those also will relate to standards. But in short, my answer will be, I think it will be a public-private. There'll be input from organizations like ISO, IEEE, and others, but with a state guarantee behind it. certainly when it comes to public services.
Thank you, Jan. I think given the time, we will probably close up there and allow the rest of the discussion to continue in the next panel, because that will also be thinking about how we legislate. So that'll probably be a better opportunity to discuss the second question as well, and also to think about how we can make things enforceable. So I think it's time for another 15 minutes of coffee, and then we'll reconvene around 3:20. Thank you.
Good, very much.
Okay. Welcome back, everybody. This is our last panel. So in the morning, we have discussed the different types of regulations, the sectoral or domain-specific regulations. And now is the question, why don't we follow another approach? That's omnibus approach. That why don't we have a comprehensive, all-encompassing regulation that applies across domains and across sectors. And to discuss that issue, we have panelists, well-distinguished panelists, and I will introduce them according to the order in your in the program. So we have Professor Luca Belli, who is joining us remotely. I hope. Thank you. So Luca is a professor of internet governance and regulation at the FGV Law School, where he directs the Center for Technology and Society and the CyberBRICS project. He is also the associate researcher at the Center Detroit Comparative of Paris 2 University and editor of the International Data Privacy Law journal published by Oxford University Press. Lucas' research interest explores the regulation and digital policy issues, with particular interest in the digital policy and regulation of BRICS countries. Thank you, Luca, for joining us. Next will be Laurie Perrine. Laurie is an associate researcher at the National Institute of Standard and Technology, US, and a doctoral candidate at the University of Maryland's iSchool. Her research explores the socio-technical approach to AI in various domains. Laurie has a respected career as a STEAM and energy policymaker, alliance executive, and consultant. She has served on presidential transition team. She held executive positions in the White House Office of Science and Technology Policy, and in International Technology Alliance, and sat on intra and intergovernmental councils. Thank you very much, Laurie, for joining us. And the third panel will be Kim van Sparentak, who is a member of the European Parliament for the Groen Link political party. She serves on parliamentary committees, several parliamentary committees, including the Special Committee on AI. With this committee, Kim committed to AI that serves society and respects fundamental rights. She focused on non-discrimination, AI, sustainability, and protecting workers when using AI. Thank you, Kim. And our speakers will be joined by our discussant, Sarah Chandra. Sarah is a senior policy advisor at the European Digital Rights, leading the work on AI policy. Her work includes the development of specific regulations on the AI Act from fundamental rights perspectives. Sarah is also a racial justice and AI fellow at the Ada Lovelace Institute in London, and an advisory member to a number of initiatives tasked with ensuring inclusion and non-discrimination in the digital policy and activism. Thank you so much, Sarah. So we will start our presentation from Luca, and I will kindly ask our speakers to stick to the 15 minutes presentation so that we will have time for the discussion. Thank you very much. Luca, the screen is yours.
Good morning or good afternoon to everyone, and thank you very much for having invited me to this very interesting event and this very timely discussion. I would really like to thank all the organizers for the great effort they have been doing, and offer an apology if I couldn't make it today in Oxford, but I'm sure there will be further occasions either in Oxford or in Rio de Janeiro or anywhere else. Now let me quickly share my presentation so that we don't lose any time. And so can you just confirm that you can all see the presentation I'm sharing in this moment? Can you just confirm that it is visible? Can anyone confirm the PowerPoint is now visible for everyone? Yes, it is visible. Excellent. Perfect. Okay, so very quickly, as it was very well announced, my name is Luca Belli, I'm professor at FGV Law School. So for those of you who have never heard about FGV, is both one of the main academic institutions in Brazil. It's also a think tank, currently ranked as the third most influential think tank in the world, out of more than 11,000. And there I coordinate the Center for Technology and Society. That was the first center to be created in Brazil to discuss the impact of technology on society. And as also was mentioned, I coordinate also the Cyber BRICS project, which is a very interesting project I will use for my presentation of today, mostly material developed by the Cyber BRICS project, which is the only existing research project mapping and comparing digital policies in the BRICS grouping. So Brazil, Russia, India, China, and South Africa. Especially we refer to this tool that you can find on the Cyber BRICS website, where we compare data protection regulations, and there's also a section on AI regulations. So if you want to check it, it's everything is in free access, of course. And also I will refer to some upcoming publications that will be presented in a couple of weeks at CPDP Latam, the Latin American version of CPDP, that we organize at FGV on 12th and 13th of July. Now, without further ado, let me just present very quickly the outline for today. First, some context to understand why Brazil is regulating and is putting forward actually several bills that are going to be into a unique bill, and what is the content of this proposed AI framework, what the lessons from existing efforts to regulate technology should be, in my opinion, considered more carefully. And then I will focus in the last couple of slides on what I call the elephant in the room with regard to AI. Now, first, the context. It is very important to understand that Brazil is a very complex country, not only because of inequalities, size, but also because in the same country coexist very different realities in terms of technology. Part of the population maybe has not access even to basic internet connectivity. Part of the population has access and develops tremendously advanced AI, and AI is already largely utilized in Brazil for e-commerce purposes, facial recognition, security, law enforcement, you name it. And there are really a lot of applications of AI that are already in use. And this is actually why the attention of the legislator and of corporations and on civil society at large on this issue is particularly concentrated over the past couple of years, because we understand that is already impacting our life in Brazil. You see here a very minimalistic timeline to understand how different policy initiatives were developed over the past couple of years. First, a consultation to elaborate a national strategy was launched at the end of 2019. Before the end of the period to submit contributions was introduced in the parliament, in the Congress, in Brazilian Congress, the Bill 21/2020, which is the main bill that we are going to discuss today. Then the pandemic arrived. AI, of course, was substituted by other priorities in the political agenda. At some point, the AI strategy was approved, and there were a lot of critiques on these strategies because virtually virtually all of the contributions were not really considered and integrated. So there was a huge frustration amongst all those as our center who submitted a contribution, because it was really not taken into consideration. No contribution was taken into consideration. It was a very basic strategy. Then an urgent request was introduced in the Congress to to vote the AI bill that was introduced at the beginning of 2020. The bill was approved by the lower chamber, so the Chamber of Deputies, less than 6 months after the strategy, and with virtually no consultation in the middle of the pandemic. So you may understand that for Brazil, that has a country, especially with regard to digital policies, used to a very participatory policy making with a very multi-stakeholder culture, this was very bizarre. So the Senate that now is evaluating this bill created a commission of jurists, so lawyers, to help evaluate this bill. The commission has created a series of consultation of multi-stakeholders consultation. We participated to several of those consultations, and the final bill will be, let's say, reshaped in a report that will be submitted in October. Please also note that October is the moment where there will be presidential elections in Brazil, so it's highly likely the bill will not be voted before next year. Now, having said that, I think it's useless to list all the reasons why this kind of multi-stakeholder consultations are essential with regard to AI, to understand a lot of elements that, as a jurist myself, as a lawyer myself, I can vouch lawyers alone cannot understand without the help of data scientists, economists, sociologists, name it. So here you have a very brief list of why this kind of multi-stakeholder approach is essential, in my opinion. And then to go straight to the content of what is, and really the core of what is going on now, the Commission is trying to consolidate 3 existing bills that you see here, not very prolix bills, as you may see, 6, 7, and 10 articles. The bill 21/2020 that I was mentioning is the largest one, if we can say so. And so the goal of the Commission is to consolidate these bills and include inputs from society to achieve an expanded version of this bill. What is the content of the proposed framework? If you want to read it, you can, read Portuguese, you can find the English translation on cyberbricks.info. And it is largely inspired from some ongoing international initiatives, some of which were already mentioned today in this conference. The definition of AI is very, very similar to what is proposed by the European Union and in the Artificial Intelligence Act, or the proposal for Artificial Intelligence Act. I will not enter into the details because it's quite long to read, but you may find it both online, and anyone interested in the presentation, I can share the presentation. Now, some general remarks. First, the current bill is very light touch. It's a principle-based bill, which can be very interesting approach if you want to have this bill voted and approved soon, but it's likely to be ineffective as a regulatory tool. And also it lacks standards of implementation and oversight. There is a lot of delegation to sectoral regulation, and this per se is not really something ineffective or wrong, unless you consider that regulatory agencies like the Energy Agency or the Pharmaceutical Agency of Brazil, the Aviation Energy, will be those with a delegation to specify the use of artificial intelligence. And at present, in this moment, we do not have in those agencies teams of data scientists, of people that may be suitable to regulate. So it's very hard to understand how this could be de facto work. And also a point that I will stress in a couple of minutes, it's likely to create some conflicts with existing regulations, especially data protection regulation. Now, the first point I would like to raise is the principle of non-discrimination that is included in the bill in Article 5, but it is included in a very specific way. Sorry, the non-discrimination principle is defined as the need to mitigate the possibility of using system for illicit or abusive discriminatory purposes. But this mitigate is peculiar, because if you think about the very large spectrum of potential risks and the various annexes, for instance, the UAI Act includes to specify systems that present those risks, only very in a very laconic way, speaking about mitigating the possibility of risk without prohibiting specific risks that we know exist. It's a very peculiar choice from the legislator. Similarly, when we speak about transparency, again, I will not read all this. It starts well. So transparency, of course, is the right to be informed in a clear, accessible, and precise manner. Then it defines in which cases the users of AI should have this right when, for instance, they speak with chatbots, or when everyone needs to know what entity or person is responsible for the operation of AI. So far, so good. But then the last part is the trickiest one, because it also states that the general criteria according to which AI works have to be communicated whenever there is a risk of potential the risk of a potential considerable risk to fundamental rights. So this specification, only the communication of this criteria of how AI works, only where is a potential of considerable risk to fundamental rights, is very peculiar choice, because it directly contradicts what already is in place as a regulatory framework in Brazil, and notably the Brazilian Data Protection Law, Article 20, that creates a right for all data subjects. So in case of AI processing personal data, all individuals, data subjects, have the right to request the review of an automated process based on the processing of AI, whichever process that affects their rights. So this is an even larger vision and larger protection than what we might find, for instance, in the EU GDPR. And at the same time, controllers have an obligation to provide clear and adequate information on the criteria and procedures used for the automatized decision, meaning that is the norm, the law prescribes that this kind of information are provided for any kind of automated process, not only when this presents a risk for fundamental rights. So the reduction, this specification included by the bill, is very tricky, because actually would not only contradict the existing legislation, but also open the door to various kinds of abuses. And then I will touch very briefly upon liability, because there is it's again specified in the Article 5.6 of the bill. The general rule would be what is in Brazilian law is called subjective liability. Also in continental European law is called subjective liability. So it would be upon the user to prove specific damages, for instance, discrimination, which are a consequence of the use of AI. Now, if you think that the layman, the average user of AI, does not have a PhD in computer science, is not a lawyer, so it would be what Romans already 2000 years ago called probatio diabolica, so nearly impossible for an individual to prove this and to use this effectively as a way of seeking redress. I will not enter into the rest because I know that we have very limited time, and I will just keep to the very concluding part. First, making good use of what already exists. I was mentioning there is already a general data protection law, for instance, when AI is based on the processing of personal data. You can find it traduced in English also on cyber-info. And there you can find already some very useful principles: transparency, security, non-discrimination, prevention, accountability, all essential for AI in general, and particularly for AI based on the processing of personal data. Also, very clear rights on access to information, existing processing, and also non-discrimination, as I was mentioning before. The very important point that I think should be also expanded is the possibility, the power for the data protection regulator to request a data protection impact assessment. And this we increasingly see is something for a fundamental right impact assessment, an ethics impact assessment is something that may help a lot in shaping AI as we want. And to conclude, the last point that I think is fundamental is the elephant in the room. And I think, honestly, in almost any AI framework that I've seen so far, with the exception of the Chinese, which is the fact that having a well-crafted regulation, and also even if one achieves not only a very well-crafted regulation, but also an effective, well-researched regulator, that is only part of how a state or any kind of stakeholder may shape AI in the future. The most important part is also how you fund, how you bake your values into technology by funding the kind of technology that you think will be useful and suitable from a societal perspective. And to this extent, it's very frustrating, again, to see the budget, the research budget that Brazil allocates in general, not only to AI in general, which has been mounting until 2015, and over the past 7 years has been slashed to less than half than what was 7 years ago. So in this regard, I think that that is a point that should be a lesson that should be learned by all legislators eager to frame AI. The core difficulty is not only having a good law and a good regulator, is to having also a good fast funding system that allows the kind of innovation, the kind of AI we want to be produced, because it is encouraged, because there is research in that sense. Otherwise, only private entities that have large financial capabilities will be able to do that research. And of course, they will do it in their interest, because that is natural behavior of any private entity. So on this injection of optimism, I will thank you for your attention, and I will be available for any kind of questions in the Q&A. Thank you.
Thank you very much, Luca, that presentation. Lori, stage is yours.
So good afternoon, everyone. I hope that you're all properly refreshed after coffee and tea, and that you're able to stay awake through the rest of our panel this afternoon. My name is Lori Perrine. I'm affiliated with both the University of Maryland and with the National Institute of Standards and Technology for the US government. My presentation today is going to be from the standpoint of the University of Maryland, although I at times represent US government policy. Today, I am not representing that policy position, but I am commenting on that. And so I want to be clear about that. Before I start, I want to just reference some of the previous panel discussions that we've had, where what we've seen is that although AI has many benefits, and it's used quite broadly in our society already, there have been a number of incidents that alert us to the risks that come from AI. And their risks to individuals, their risks to communities, their risks to the environment, their risks to structures within society. Therefore, one of the things that you will see in the US approach to AI is a recognition that we need to understand those risks from the beginning of our AI life cycle, so that when we start to design and develop a system, we need to be able to already anticipate what types of risks and harms are possible in the particular context and application that we have. So to do that, that requires a change, a transformation in the culture of AI. And so it's from that standpoint that the US strategy is made. So let me start by giving just a little bit of context with respect to that. In January 2001, the national AI strategy came into effect in the United States. The United States obviously has been involved in discussions with respect to AI, AI governance, AI potential regulation, lots of R&D long before 2021. But it's in 2021 that this all came together as a coordinated effort so that several strategies could be pursued. And you see those 4 pillars there in the slide. Clearly, there was a need to look at how we could deploy applications and infrastructure of AI in a more systematic way, in a way that took into account safety, national security, economic impacts, social impacts. And so that was kind of ad hoc at best. Before 2021, we're only a year in, but there's a little bit more coordination of that. There was also a need clearly to develop a process for ensuring that AI had the public trust. And that's where regulation comes in. There was also a need to coordinate R&D better across federal agencies. And there was a need to address workforce issues with respect to artificial intelligence. All of that had already been part of discussions at the national, state, and local level, and also obviously had been part of international conversations as well. The US, as we've heard from some of our previous speakers, is a very proud partner in many international organizations and international conversations, sometimes even given an honorary role in driving some of those conversations as well. And so it's on that basis that I want to talk a little bit about trustworthy AI, what we're calling trustworthy AI in the US national context. It could be seen as responsible AI. There are many synonyms for that, but that trustworthy AI is the goal of potential regulatory activity in the US context. And you'll see there these various building blocks. This happens to be one slide that I took from some of my colleagues. There are variations of this slide because sometimes we talk about transparency and accountability. Here you see explainability and interpretability, which are kind of cousins to those things as well. We talk about privacy or data protection. We talk about safety and whether that is safety of systems, safety of human beings, safety of environment. All of those things are included. And then our technical friends it's very, very important for us to have accuracy, robustness, and reliability of systems. So those are some of the basic building blocks that underpin what we want to achieve with a trustworthy AI framework. Now, this is just a list of principles. I'm not going to read through the whole thing. You can be reading that behind me as you look at it. One of the things that's important here is that the US, this is very typical of technology development in the US, where there is this approach of let's try to have voluntary, non-regulatory consensus to the extent that we can on voluntary standards. We've heard talk about our friends with the ISO standards. NIST is a standards making body in addition to some of its other missions. So let's have as much consensus, voluntary consensus as we can, and let's use existing regulatory frameworks to the extent that we can in order to advance the technology, accelerate it in some ways, make sure we're not creating barriers to innovation, but also be sure that we are respecting the rights of our citizens and that we are not creating harms in places where harms have already been created or where there are not emergent harms. And so that's been a long time strategic frame for the US, and that is that is still a strategic frame for AI. But what you've heard from our previous panelists is that AI is a little bit different from some of the other technologies. There's certain different characteristics to that. One of them being that AI affects many sectors, and it can show up in many applications and use cases, and it's not necessarily identifiable easily in some of its outcomes. And so in order for us to be able to have a non-regulatory approach and identify where are the gaps in our existing regulations. So here are a bunch of existing regulations that can be brought to bear for artificial intelligence. These are things that protect our society. They're anti-discrimination. They're related to finance and antitrust. They're related to workers, labor, safety issues, etc. Many of these are regulations that can be and that are being used to address AI. But as we heard in some of the initial presentations, the question that we need to ask ourselves is, are they sufficient? And where they are not sufficient, what is it about AI in particular that we need to address in order to ensure that we are not accelerating risks, that we're not amplifying the risks, and that we're not creating new risks and new problems? So the approach that the US is adopting as a primary approach right now is based on risk management. And this risk management, this lovely diagram that you see here, is rather generic, actually. The US has used this type of framework, risk management framework, for cybersecurity. They've used it for a number of technologies, where the idea is that we map the functions of our technology so that we have a better understanding of its inputs, of its use, that we measure the function of that technology in operation against what it is meant to do, and that we have management in place to make those decisions about what to do with the technology and its outcomes. And then across all of that, there's governance that is sown throughout that gives us an opportunity to look at how we can ensure compliance, how we can ensure harmonization with existing frameworks, existing laws, existing norms. In the case of AI, what we're saying is that it's time for the tech community to change the way that it maps in particular, and to broaden its perspective with an understanding that it's not just about the data, it's not just about the algorithm, but it's about deployment of a system, a technical system within a social context. And that social context, and especially the risks that may arise from use of that technology in a social context, need to be analyzed from the very beginning, from the time that we begin to think about designing the system. So what that means is that when we think about potential risks, such as bias, okay, so bias is one of the common harms or risks that we see arising from technology. We talk about bias in algorithms or bias in data. What we say is, you know, there's more to bias than just technical and statistical bias. In the process of developing an AI system, there's going to be cognitive bias that enters into that development. There's going to be systemic bias that enters into that development. The way that we actually look at and develop the tools for collecting data, what data we do collect, what relationships we decide to model, all of those come from certain systemic biases in the ways that we look at the world. So this particular chart and some others come from a special report that I and my colleagues wrote that we always refer to it as SP 1270, but this is about managing bias in artificial intelligence. And so I invite you to look at that document a little bit more closely. It is bias-centric. So when we think about this in terms of a risk management framework, in terms of a life cycle, what's missing? What's missing is understanding of the full context and the full set of factors that go into that risk profile related to bias. And so it's with that idea in mind that we talk about creating a risk management framework and the particular implementation details. And this is where what we're doing at NIST is a little bit different from what you've heard from our colleagues. That we are going into implementation details about if we're going to address mapping, if we're going to address measurement, if we're going to address management and governance in a way that has a socio-technical perspective, how would we do that? And the main features of that are that we need to look at our system from the broader perspective, as I said. We need to have, from a governance standpoint, full organizational buy-in within the organization and within the industry or within the governmental context, if these are state actors within our system. And that there needs to be, this is kind of interesting for my tech friends, there needs to be greater observance of scientific integrity and the limitations of what the system can do. Because not all systems fit all. So if we're going to broaden our context, here's a different way of looking at our stakeholder community. The folks who have their hands on the AI system are not just the developers and the designers. That little ecosystem has to include the operators and the deployers, but it also has to include representatives that you see here, folks with domain expertise. Oh yeah, so they're often in the room, but we don't often have experts in the actual or intended settings for the system. We don't always have folks from civil society or folks representing the human-centered design perspective. We're also saying that, you know, just so those of you who have a technical orientation, you'll realize this looks like a neural network, okay, with its hidden layers. So often what are hidden in the system or not made explicit are who are the beneficiaries of this system? Who's funding it? Who's calling the shots and making decisions about where it's going to be deployed? And who is making decisions about who's going to get a job or who's going to get a loan or who is going to be arrested based on what's coming out of the system? Who are those decision makers? And what we almost never see are who are the impacted individuals and communities. And we're saying that flow of information has to be there from the start, and it has to be part of the entire life cycle. What we're also saying is that, and I sort of spoke to this before a little bit, this idea of scientific integrity, the example that was given about the fiasco in the Dutch system. When you get away from the ethical the ethical horror of that, there's a mathematical horror in that as well, which is that basically a model was constructed using all kinds of proxies that were meant to indicate a particular construct of people being susceptible to committing fraud, but there was no validity in the selection of the measurement models and the construct that was meant to be measured. And so one of the things that we're asking our community to do, what we're asking folks using this risk management framework, that would be industry, that would be potential regulators, that would be civil society watchdogs, is to look at how are these algorithms constructed beyond statistical bias? Is there scientific integrity even in the choice of what variables are being looked at? And how is the data collected as well? And as I've said before, one of the things that you will see in 1270 and in the framework throughout is this need to really incorporate human-centered design at all phases of the life cycle. It's not just a human in the loop. It is also an understanding that cognitive bias, human values, societal values inform every aspect of the life cycle of that technology. So how then do you, as an organization, account for that in your processes? Some of that we are spelling out as suggestions in the framework. Some of that are things that have to be worked through on an organizational and an industry basis. So where is the NIST activity at the moment? This is an ongoing activity. You heard from some of our previous panelists that there was a workshop earlier, about a couple of months ago, where there's a lot of input from the international and national community, and we created a first draft of this framework. We're in the process of creating an implementation guide that is being commented on by a multi-stakeholder engagement process. And it is our hope that it will probably be this fall, because my email is full of emails to review some of the comments, but this fall we hope to have a third workshop and a second draft that includes that implementation plan for broad comment. So that will be available to you sometime probably in September. And then an initial final, because this is a living document, will be available as well. Now, I'm actually at the end of my presentation. I just did want to mention that there actually is legislation that is proposed, that is out there to look at accountability in AI. But those folks are waiting for what's happening in the risk management framework process. And so what you'll see is as this moves along, there will be increasing references to what's happening with the risk management framework. And that bill will change to address where some of the gaps are as we continue to engage the community to find them. Some things that may present challenges to us very quickly are, is this sufficient? This approach, is it sufficient for general purpose AI, where we can't really define the use cases and the applications? Possibly. Third-party issues in procurement. I mean, that's a big issue, especially when you have governments that are purchasing third-party systems, but you have banks that are purchasing the systems. You've got police departments that are purchasing these systems. How do we address that in terms of the framework? So we're actually creating new elements to the framework to work with that. Are the governance structures that we have presently sufficient inside of organizations, but also in terms of our not just regulatory, but other aspects of our government system? And then finally, as we're doing this, we are talking quite a lot with our friends at OECD, the folks doing the ISO standards, IEEE, and then there's like a whole list of other folks who have their principles and their taxonomies, and we all need to be somewhat coordinated with that, although the emphasis is different. So, making sure that we get that harmonization, once again, not a one size fits all, but one that respects that we are part of a global community and there is that global need, but there's some specific needs that are within the US context. So thank you very much, and I'll look forward to our discussion.
Thank you very much, Dory. Kim, the stage is yours.
I have a PowerPoint presentation. I'm not very used to PowerPoint presentations as a politician. My name is Kim van Sparretak. I'm a member of the European Parliament from the Netherlands. I'm a member of the Greens, and I am a shadow rapporteur on the Artificial Intelligence Act and also on the Platform Work Directive, which of course has a large extent to do with AI at work. So thank you so much for also inviting me. And yes, when we're talking about the AI Act in Europe, I think it's interesting to look at the title of this conference, The Race to Regulate AI, because in the first speech by Ursula von der Leyen, the Commission President, she said, within 100 days, we will have an AI Act. And well, it took a little bit longer, just a little bit. But now we have one. At least there is one proposed by the European Commission. And at the moment, the member states and the European Parliament are discussing their positions on the act. And then in the end, we will negotiate with the three of us to come to the final act. And perhaps it's good to set the scene also a bit on what was the approach of the Commission and how was it envisioned. Of course, AI can definitely benefit our lives. We see very amazing results actually when it comes, for example, to healthcare, finding diseases faster, etc. But you know, we know that there's a lot of risks. And yes, I'm also going to talk about the child benefit scandal because I am from the Netherlands, and it is just one of these incredible examples where a simple algorithm went so wrong that it is one of the best ways to learn, unfortunately, because so many people's lives have been devastated. Maybe, I don't know if everyone was there when Jan, my fellow Dutch person, explained it, but very briefly, there was an algorithm that had to check whether people were fraudulent with child benefits, childcare benefits, and in the end, there was a very big group of people that were flagged as fraudsters, and more than 50,000 people were flagged as fraudsters, and they all had to pay their money back. But because of the way the algorithm was designed, these were mainly people with a low income, people of color or with a non-Dutch background, and they got into huge debts, and more than 1,700 kids that were taken away from their parents are still missing. So they're somewhere in the foster system. So yeah, it's just a horrible story, but it's one that when I found out I was allowed to work on the AI Act on behalf of my group, I wanted to use as an example to also look at how can we use the AI Act to make sure that we minimize the risk to have another one of these kind of scandals ever again. So when you look at the child benefit scandal, it shows that that a simple algorithm can harm if we don't have the right, you know, parameters in place to make sure that we use technology in a proper way. And the Commission really put forward this idea of, okay, they wanted to be the first to regulate AI in the world and to have a human-centric approach. Well, then it took a while. It took a while before they came with a proposal, and in the end it came out. And what is actually quite interesting is that the way that the Commission wants to regulate AI is by using a product safety approach. So really defining, you know, AI as a product and making sure that it's safe. And of course, then you look a lot of technological standards, then you look at de-biasing the technology in itself. But I know that, you know, one of the things that we've been talking a lot about today is actually the human rights aspect. And when it comes to human rights, it's not only about making sure the algorithm works well, but it's also about looking at when it's deployed and how it affects people and how we deal with it when an AI system is being used. So that's why I don't think you will be very surprised if you hear that from the Greens, we had more than 400 amendments on the AI Act, and from other groups there were also a lot. We didn't even have the record in most amendments, because we want to actually try to fit a human rights perspective into a product safety system, which is really, really complicated. So, product safety approach. So it's actually very familiar for people who know a bit how product safety works. You have a new product that comes on the market, and that might be very dangerous, and then it has to go through a whole system, and it has to just be up to certain standards, and otherwise it's not allowed on the market. That's basically how we have organized this in the European Union. It follows a risk-based approach. So if your system might have high risk, then there are stronger rules than if it's a low risk system. That's why the proposal also has a list of high-risk users, say healthcare, for example. When you're on this, you fall under the high-risk list, then you have to take extra precautions, and you have to check whether your product is up to standards. And then the proposal also has a second element, which is a list of bans. When are you not allowed to use the AI? It was actually quite hopeful to hear the story of Jan, and hearing how much they actually want to ban, because the Commission was very careful with coming up with bans. But I can come back to that a bit later. So basically the AI Act has three parts. If I would sort of, I don't know who has read it and who has actually managed to completely understand everything. We've been talking a lot with the Commission to figure out exactly. There's two different things. It's been quite hard to actually see, like, okay, this is what they wrote down, and this is what it then will look like in practice. And it's really important, of course, that if we have a law, that it will actually be useful for the people who have to use it. And they don't have to do like this whole system of trying to figure out how it works. But in short, you have high risk that has to be up to certain standards, and you have things that are not allowed. Like shortest, I think that's the shortest summary of the law. So, as I said, we put forward more than 400 amendments, and I think that's because of several reasons. First of all, because it's very much based on a market ID. It's the ID that you put a product on the market, and that we have to regulate a bit. And and then when it's on the market, then we see what happens. And I think also the second part is that because of that, it really focuses on the design phase of the product. So when it's designed, then it has to be flawless. Well, let's go back to the child benefit scandal. It's a perfect algorithm. It did exactly what it had to do. It was a very simple algorithm. The way it was made was very dubious, but the algorithm did what it had to do. The algorithm said you have to check whether people make enough money, whether they have a higher amount of kids, whether people have the Dutch nationality or not. The algorithm did that, and that's what came out of it. It's very clear that, if you only focus on creating a perfect AI or a perfect algorithm, you are not going to diminish the human rights impact that it can have. And that's why one of the proposals that we have is that you should have a fundamental rights impact assessment when it comes to high risk, specifically when you are using the system. And I think we've already discussed it quite a bit today, what a fundamental rights impact assessment would be. And I also truly believe that if one person in the tax authority would have had to do a checklist on whether they were, I don't know, being racist, then they might have flagged, oh, maybe this is actually not the right way to use an algorithm. And, a lot of damage could have already been diminished. Then one of the other things is that we see that, it's a lot of voluntary proposals that the Commission put forward. So, for example, when you use a system that is very high risk, you can just say that you have checked it yourself. And that's why we would like to see a third-party conformity assessment to make sure, that we actually have a third party checking whether your system is all right or not. I think when it comes to the scope of the act, it has to be a broad scope. The child benefit scandal was a very simple risk model. So if we would only go for the super high, like futuristic AI systems that bring everything in the world together, then we're also not going to diminish a risk to get something like that again. And also, we see that there's a lot of discussion in the European Parliament on whether to, for example, exempt general purpose AI, which would mean that like 80% of all the AI in the world would basically not be part of the AI Act. And that would also mean that, if you want to use general purpose AI, all the risk of that general purpose AI is up to the person who's using that then, which would mean that the biggest companies, because those are the ones that creates general purpose AI, would just get out of their liability, and like the little companies that are trying to create AI with that general purpose would have all the liability on them, which I don't think is a very fair way of dealing with legislation. Then I think what is very important is that the fundamental rights aspect should just be strengthened all over with the fundamental right impact assessment, but also just by making sure that we look at fundamental rights at several stages in the system, and also by empowering people, making sure that people are not forgotten in the whole process, because we have the whole story about AI is that we have a human-centric approach, but then when you read the text, it's about technology. It's not about people, and it's not about people having the right to know about every algorithm that exists that governments are using, for example. And that's why we would like to see an algorithm register all over Europe, where people can just look up which algorithms are being used. Amsterdam is a great example. I mean, the ID is a great example. There are now, I think, 6 algorithms in the register, but they have already set up a register where, in principle, all the algorithms that they are using, that you as a citizen can encounter when you're dealing with the government, is in there. And I think, when it comes to transparency, but also when it comes to creating trust in something like AI, which for a lot of people is still, the things we've seen in Alien with this scary robot that explodes and everything. I don't know who's seen Alien, but I think it's very important that we create transparency. Just for the people who don't know Alien, they find out that one of their friends is actually a robot. That's the scary thing about it. Okay. Anyway, also when you look at empowering people in the AI Act, it's very important that people can go somewhere if they've been affected, that there are proper redress measures, and that they have the right to ask why a certain decision was made. And lastly, I think it's very important that that there should always be human oversight. And I think, and it is something that sounds so obvious, that it can't be just an algorithm that decides whether you get fired, whether you can get a mortgage or whatever. But in practice, we see that people believe in computers more than they believe in people. And actually, people believe in computers more than they believe in themselves and their own opinions. So it's just very important that we make it very clear that you can use AI. Because the often heard example is, of course, someone didn't get a job because they were discriminated by the AI system, because, when they looked at LinkedIn, all the CEOs were men, and then women were not considered being a good CEO. But there are actually also AI systems that flag biases in, within the recruitment procedure. And I think, those systems would be actually something positive, but we just have to make sure that it's something where people and computers work together, rather than a computer deciding everything and a human just saying, I guess the computer's right. So that's one of the things we really would like to see in it. And then a last point that is very important, and perhaps not very surprising considering I'm a green, is that we want to have also a look at environmental impact. Because for now, the environmental impact is there was a leaked earlier draft, the environmental impact was in there, and now it's not anymore. So we just put it back in our amendments, because in the end AI can have a very big environmental impact, not only the data centers and the systems, which is of course also a very big impact, but also it can just have an impact on nature and the environment and the climate. So that's for us something very important to work on. So as you might hear, we have quite high ambitions for how we want to improve the AI Act. We think it's necessary, but whether the political will is there in every political group in the European Parliament, that's going to be interesting. We still have but any law will, stop innovation narrative that is extremely strong in the European Parliament. Also, like guiding innovation is something that, I don't know, for some reason, which I think would be very good, because like when we're talking, for example, at the bans, we would like to see a ban on biometric surveillance. And then it's like, oh, but then other countries will be better at biometric surveillance. And I'm like, I don't think we want to be good at biometric surveillance in the European Union, because it's, against fundamental rights. And we say we are the fundamental rights hero of the world. At least that's how we sometimes tend to position ourselves. So I think those are some of the tough discussions that we're really going to have. And then I'm always a bit disappointed that so many of the things that we discuss in the European Parliament, the real negotiations happen behind closed doors, because then the people who are saying human rights are important, like when we have a public hearing, and then behind closed doors, like, but fundamental rights and human rights shouldn't be a burden for companies. Those dynamics are always very complicated, but I know that we have a very strong negotiation team. Luckily, there's a lot of progressive and, may I say, young people also working on the AI Act, who really who understand the algorithms, who understand AI, and who understand that a technology is not just a neutral thing. So I'm hopeful, but it's still going to be a long process. The timeline has already been extended for 2 months, I think, or something like that. So we don't see a final result coming up very soon. But yeah, please make sure you also stay up to date on what is happening in the Parliament. And if you see that some things are going wrong, just saying, I'm a smart person, I know everything about AI, and please don't believe in the narrative from big business, would always be very welcome. So I'm just a politician. I can't do everything on my own. I need civil society. I need the science community to support us. So please feel welcome to do so. Thank you.
Thank you very much. Thank you, Kim. That's interesting highlight for the developments in the AI Act. And now it's time to hear from our discussant to summarize all the different perspectives and contribute to the debate. Sarah.
Thank you. Okay. There's a lot of things I could summarize, and I don't think I will be able to achieve that in this short amount of time. So what I will do is do my best and give some reflections in an attempt to give some more broad reflections, speaking to what has been discussed today and its consequences for like a more global approach to AI regulations. What are the similarities? What are the features? What are the challenges that are appearing in all of them? What may be the mistakes also that are appearing in all of global forms of regulation? And then I'll also try to give some reflections also that speak to some of the other panels that we've heard today, especially what I think, and I think I maybe share the sentiment in the room, the panel that you gathered on labor, especially the extent to which it spoke to structural power imbalances, extraction, and really broadly this question of the relationship between AI and inequality. So to start, I think in each of the presentations today, we heard about starting from the process of harms. And I think that in itself is quite a subversive technique to enter for the entry point of this debate on AI regulation, to start from a process of harms, as opposed to a general process of presuming innovation is always beneficial and not questioning this question of interests, who benefits and who doesn't benefit. who gains and who loses. These are very simplistic, obviously, and perhaps reductive questions, but in essence, we need to at least ask them, which often we do not do in AI policy. So we started with a really great sort of summary around different harms. We talked about the Dutch welfare benefits. Laurie talked about some in the criminal justice space. There are some, many actually, potential discriminatory impacts, especially rooted from the US when it comes to the discriminatory use of AI in policing and criminal justice, but also in other contexts as well. We've seen in the Brazilian context, you noted that there's a number of different credit scoring uses. All of these have different harms, and let's start from this process. I think the point that came to me on this point is that Laurie's point about the contextualizing these harms. So often when we have a conversation about AI policy, we frame harms in the context of design of these systems. So if they were just designed differently, if they had better data, if there were more women in the room, maybe the structural impacts on society of these algorithms and of these AI systems would be better. Maybe they'd be less horrific, maybe they'd be less discriminatory. I think this question about contextual impact and contextual use is really key, at least for us in the EU policy debate, because a lot of the technical standards that Kim noted as the cornerstone of the EU AI Act. So if you're high risk, your system is high risk, you have to meet these technical standards and then you're good to go. They stemmed from an assumption that design is very central in terms of the structural impact of AI systems. So if we just improve the technical aspects of it, if we're more transparent, if we have better data quality, the harms will go away. I think that is a unsaid presumption of a lot of EU AI regulation. What if, and as Laurie has said, the harms are also socio-technical. They stem from the socio-technical context, also an environmental context. What then? How are we understanding harms in their context of use, as well as in the context of design? Both are important. And for me, this raises the question, are the risks of AI an aberration or a feature of our society? And for me, this is a question that we should keep coming back to, because it really challenges our assumption about design, but also the role and the actually what we can expect from technical standards and processes like debiasing. If we recognize that these structural harms are existing, how far can these small, very technocentric approaches to these harms achieve those goals? How can they protect us? That is key to the bias debate. And so we've spoken about these harms of AI systems stemming from bias, societal or structural, but also we talked about it in the context of existing law, these harms stemming from discrimination. I think both of these frames are useful, especially in a legalistic setting, especially in a technocentric setting, these are useful. But to open up that question a little bit more, are these harms completely characterized in these two frames? I think not, and that's really why I was quite touched by your panel on the panel on labor extraction, because I think what bias doesn't achieve, and also what discrimination law doesn't achieve, is that AI is often used in the service of a corporate world, a capitalist structure, which has its root extraction from the worker, from the people, from anyone producing value. So from my perspective, I think one of the questions I think that comes out to it, especially in this relationship between AI and power, the reason we're questioning why the majority of people doing app delivery work are people of color or working class people, is the very same question that we have to interrogate why technical approaches to AI regulation won't work, is because it's all part of the same system, which has as its root extraction. That is obviously missing in a lot of AI policy debates, because actually it leads us to the question, is the answer AI policy, or is the question broader economic distribution, challenging the power of big technology companies, these bigger questions that maybe we sometimes don't know how to ask within the limited frame of AI policy. So stop there to go back to my notes. All of this, I think, links to another really important frame that both Luca and Laurie and also Kim brought up, especially with the context of AI regulation, is that often the policy that becomes before the regulation really centers on this presumption about innovation as a good in itself, and promote the notion that we should therefore promote the use of AI. And that was a really key recurring frame in the EU policy debate. We need to promote AI uptake at the same time as creating trust. I think this has a number of problematic manifestations when it comes to, at least from my perspective, EU AI policy, but also I think Luca mentioned them with respect to the policy of the BRICS as well. So one of the problematic results of this presumption of that we need to promote AI uptake is that increasingly, therefore, in regulation, there's a growing role of discretion. So Luca mentioned, okay, so it's coming up more and more that actually you can actually decide what is the significant impact, and who is going to decide that is going to be the deployers or the companies designing those systems. That's also coming up in the EU AI amendment. So movements to actually say that deployers of AI, developers of AI should actually be deciding whether they themselves their systems have a significant impact, and therefore whether they are subject to the rules of high risk. That's, I think, a really worrying trend, this increasing discretion in lawmaking to the private sector. And I think it was also Christina's point earlier in the broader privatization of standardization that also goes into this trend. The other one I thought that is a problematic sort of result of this presumption of promoting AI is Luca's point about the politics of research and innovation also. So we have recognized also that a lot of EU AI policy, especially, but also a global policy, has thought about how can we promote the use of AI, but hasn't actually had the question of which AI and by who do we want to promote. So we haven't had a conversation, a really structural conversation about promoting research and innovation can mean promoting the research of Google versus it can mean promoting the research of public interest organizations that need funding and are systematically underfunding, and that our global system is increasingly disincentivizing the public development of technology in the service of the people. That is a key question that I think that it's hard to address via law, of course, but is undersitting lots of the policy documents and the AI strategies that precede law across the world. So it happens in Brazil, it's happening, it's a feature of the US AI strategy, and of course, the white papers that came before the EU regulation too. One last feature I think that is problematic of that, and I think is really not seen and not addressed in most AI legislations, is addressing and reckoning with this concept of not just AI as a product, which we've unpicked, not just AI as a service, which I think is increasingly recognized, but also as AI as infrastructure, and also the infrastructure of what it means to produce AI. So Seda Gerses was mentioned before. She is doing some really important work on the political economy of AI systems. It's not just about the systems themselves that we should be analyzing the impact of, but what the infrastructure that creates those systems and enables those systems to be put into practice means for us. What that means for how easy it is for you or I to develop an app, how easy it is for a government to develop a system which can help them in the delivery of public services. All of these questions, I think, are very much obscured and not a feature of the EU AI policy debate. Maybe they come up a little bit in the European debates on the Digital Services and Digital Markets Act. But if we're not actually having that question of the broader structural impact of the AI industry versus particular small, specific AI systems, then I think we miss a much bigger part of that point. That speaks to the general purpose AI question, which has been, as Kim has mentioned, has been a wide-scale attempt to be outside the scope of the AI Act, mainly because these are the providers of these general purpose AI systems are the ones that have the most at stake and the ones that would like to evade accountability and transparency and oversight of government regulators themselves. They are the ones that produce the infrastructure for AI. And this was really much the feature of Timnit Gebru's paper and why she was fired from Google. So all of that, I think I would just like to ask the question and maybe go back to these panelists is, I think all of the points that you've made really ask the question, can we actually take a power neutral approach to AI regulation, which I think is how I would characterize most AI regulation as a power neutral approach. My answer is, of course, no. But then the question, I think, is how do we actually shift power with our AI policy recommendations? I can say a few things that I heard from the audience and from the points. So this notion of a preemptive obligation, I think that does something before deploying AI systems. I think that does something to actually shift the burden of accountability of those that seek to deploy AI. It doesn't address the power structures questions, but it does say if you're seeking to use a particular type of AI system, you have some sort of level of accountability to the people who are affected. You need to do certain things vis-a-vis transparency, impact assessments. You need to show what the impact is likely to be, and you need to be transparent about what you're using this AI system for. I think these are important, and I do think increasingly it is important to complement the existing frameworks that exist in things similar to the GDPR with the data protection impact assessments. The other points Kim has mentioned, the need to bolster rights and remedies framework. Of course, this is important to empower people through that. But also thinking about how we shift the burden of proof away from the people affected, which was a feature, of course, of the Siri case. We hear about often the impact, but we don't hear about the years of difficulty about trying to prove that harm, get people to pay attention to that harm. That wasn't an easy process, and it never is. Our difficulty is with AI, the AI harms debate, is that we often hear the results and we hear the investigative journalism about those stories, but we don't hear the long process of which it took to get to that. And we also don't hear the stories that we don't hear. So thinking also about how we can shift the burden of proof in AI regulation, I think is a key point. And that for me comes back to Vina's point about thinking about this question of abolishing AI, abolishing tech in certain consequences, and links to the red line debates that Kim has mentioned. I really strongly believe that a key feature of a just AI approach really has to be in some way including this question of abolition. It can't just rely on accountability, broad principles. It can't just rely on transparency. It can't even just rely on the legal system. It has to find ways to shift the burden of proof. And that necessarily means thinking of some types of systems and uses that just shouldn't be used. So with that, I'll end, and I'll maybe bring back to the panelists. How do we shift power with AI policy?
Thank you very much, Sarah. How do we shift power?
Or how do we have a power neutral approach?
Yeah.
I'm going to hook my answer on one of the very last things you said, which is sometimes there.
Yeah, your
hello.
mic's not on.
Okay. So I guess I'm going to get the hand mic. So there are just some systems that shouldn't be built, right? There are just some uses of AI that shouldn't be done. And that's a little bit of heresy in a technology-based community, in a technology-based ecosystem, which is what I tend to inhabit. One of the things that you saw on the, we had 15 minutes. I couldn't take you into depth on many things, but one of the things that we're trying to do is to adopt is to socialize a change in the culture of developing these technologies And as part of that socialization, to actually have not just consultation with others, but to have as part of the initial development team, a variety of disciplines, so interdisciplinary structures, qualitative analysis as well as quantitative analysis to really make explicit what are the power dynamics at play. Who are the players who benefit, who are making decisions, who would be affected by this? Are they even in the room? And so there's a culture shift, not only in terms of, let's say, adopting a socio-technical perspective, but really to get to the point of saying, should this system be built? And if it is built, let's be explicit about two things. What is the power structure that it perpetuates or benefits? And what are the actual limitations on this technology? To be explicit about where it can be used. Because right now somebody builds a model and it's like, oh, hey, great model. Let's use it here. Let's use it here. Let's use it here. We call those off-label uses. But they're not just off-label uses. Often they're dangerous uses. They're ignorant uses. And so I don't know. I don't think anything is power neutral. But I think that we can be more explicit about what are the power dynamics in any of the technology that we deploy.
Can I maybe add some things? Because what I think mine is working or not. Okay. Yeah.
Thank you.
What I think is absolutely crucial is that we also have to have a bigger conversation about AI in society. Because if we only look at it from a lawmaking's perspective, you know, we're not going to change the way people approach AI and how people believe in computer systems. And I think I've spoken with so many people who were like, yeah, we created an amazing system. For example, one that was used on the work floor. They wanted to create a system to have less accidents in factories. So they created an app where, you know, you could all the time see where the worker was, and the worker could see exactly where they were and how they had to use the machines. They would immediately automatically get a system to see how they exactly had to use the machine. And in that way, they would be, you know, there was a less harm. At least that's what they said. And then I asked them, so does this mean that their employer can track every single second of what they're doing and whether they're following everything exactly as they have to? And they just looked at me blank, like, yeah, I guess, you know. And I think, you know, when we're promoting the uptake of AI, which is one of the things that that also the Commission is doing a lot, you know, more AI, more better. But you know, without having the conversation about the impact that computers might have, and that a simple computer program is not the same as nowadays as it was 10 years ago, then I think in the end, perhaps, you know, people won't even recognize that they might use a high risk system. And then in general, the whole AI law will fall apart. And I think that is perhaps also that's why it's so interesting to specifically look at AI at work, because that's where we're seeing all these technologies being used very clearly. That's where people really encounter AI. So it's also the space where you can have these conversations with people on a daily basis. And also where you can very easily explain that the new system, you know, the new update of Word is not the same as this new system that is checking how many keystrokes you make per minute. And I think, you know, that is the other part to making sure that, you know, we change the power dynamics is also information and discussion and people feeling empowered to talk about it. Because when most people hear the words algorithm or AI, they're like, yeah, I don't understand. And I think we are still in the phase that we had maybe 20 years ago when we were talking about climate change. People were like, greenhouse gas effect. Yeah, sounds bad, but I don't know. And now we're just talking about the climate crisis. People know there's a crisis and we have to do something. Let's make sure that people feel as empowered to talk about AI and algorithms without having to completely understand how to develop an AI system, but at least knowing some things before we get to an AI crisis.
Luca, can you hear us? You can continue.
Yeah. I raised my little yellow hand here, but I thought it was better to raise my own hand. I've noticed I'm on you. I wanted to add a comment, just a very quick comment, because the last couple of comments have been very eloquent, and I had just a very few. Well, really just two remarks that I think complement what has been said. And well, first, with regard to the question on if whether AI can be value neutral, let's say, and I would say obviously not, because usually any technology embeds the values of the builder, the developer of the technology. And I would say that aware of this consideration, in my view, there are two. Well, there is another key consideration that is, let's say, bidirectional if we consider AI and what values, so knowing that cannot be value neutral. So what are the values that we embed into AI or technology? And here, I think that's, again, one of the points that I wanted to raise, and I hope I've been successful in my presentation, is that regrettably, many AI or technology regulation efforts, even those that are considered as golden standards and source of inspiration by the global South, namely EU or US approaches, they concentrate specifically on building a law or a regulation, is what actually in the event today is about. But regulation is not only about law, is not only the classic legal tools that regulate, it's also about incentives, it's also about technical standards. And so I think in my view, there are two directions in which this interacts. On the one hand, bringing social values, so the values of society within the instruments that will shape technology. And again, I think that it's interesting to look at non-Western, let's say, approaches, because there is some very interesting initiatives that are proposed. For instance, I'm not sure if the participants are aware that Argentina is proposing a multi-stakeholder council on AI that is now proposed by the government and will probably be finalized or launched by the end of the year, which is a very interesting approach to try to convey different perspectives, interests, values within then the institutions that will have the possibility, the power to regulate. And on the other, and this is something essential, conveying social values within regulatory tools. But on the other hand, those values, they cannot only be enshrined into legislation. Because again, the other point that I hope I raised in my presentation is that legislation, regulation are very useful tools. And as a lawyer myself, I know it. As a lawyer myself, I also mistrust regulation and legislation as perfect tools of regulation. They, and if we consider some very complex items like AI systems, regulation by itself or legislation, let's say, may be excellent, but then we need something to translate what we bake into legislation in what we bake into technology. And what, again, I don't see this in many frameworks. To my knowledge, the only ones that are doing this are, well, those who are trying to do this seriously are the Indians, and those who are really doing this are the Chinese, creating guidelines, basically translating the law for the developer. If a developer does not, we have seen this, again, data protection is a very telling example. If the best possible regulation exists, but the developer or those who have to shape their organization or their technology according to the law, they don't even know that the law exists, or they don't even know how to apply the law to implement it. It's very frustrating to spend a lot of efforts into a law that then does not correspond to the reality, and the reality does not match the law. Why? Because the law has limits as a tool of regulation. So I think that another huge effort, besides bringing diverse visions and perspectives and values into the elaboration of the law, then has to be translating the law for the developer that is not a lawyer and does not know the law. So even if the law is wonderful, is perfect, the lawyer will, the developer will never be able to integrate it perfectly. So sorry if I'm speaking too much, and thank you very much for this last opportunity to share some comments.
Thank you very much. I think we are running out of time.
Mm-hmm.
So thank you very much for your comments, and thanks very much.
Emphasis on labour, we have to be aware of certain rights under the working time regulations. And even for those of you who are here in a non-employee capacity, I think you also deserve your evening at some point. So I think it's time to conclude. It's been more than 8 hours and we've battled the tech grumblings. We've enjoyed the beautiful British summer sunshine and rain. We've met friends, new and old. We've even met in 3D, some people we've been working with for many years now, just seeing them in their kitchens or their bedrooms. Thank you so much, everyone, for coming. Very quickly, what have we learned? I think I've got 3 points or 3 sort of key takeaways from our discussions today, both in terms of the panels and also the many side discussions we've enjoyed. I think first, there's definitely a case for regulatory intervention. Now, you'd expect a lawyer to say this, but actually I think it's been really reassuring to see that it's not even regulators waking up to this challenge around the world. Regulators are very acutely aware of that need. And I think that sense of real demand, a real sort of desire for moving forward quite rapidly now with interventions, with actually regulation. And many of the sort of core themes we were playing with, I think actually have come out, not just in the employment context, but across different sectors of artificial intelligence, whether it's the information asymmetries, the privacy harms we were talking about, but also this loss of agency and this need to reestablish agency, whether it's human in the loops or various other forms of reestablishing agency. The second conclusion, I think, that we've come to is that, yes, we need some adaptation in existing laws, but we also need new regulation. And I actually really enjoyed the discussion right at the end of the first panel when Alex, Orla and Halifon were sort of going around this relationship between data protection and AI. And I think it was Alex who said, we need to build on data protection principles, but data protection principles alone are not enough. And I think that's a really good way of thinking about it. Those of us with a sort of geeky EU constitutional law hat on, well, we start thinking about minimum harmonization with the advantages and the potential drawbacks of this. It's too late to get into the geeky detail of that, but I think thinking of sort of existing regulation as a floor of rights on which we can then build and develop new rules, I think is a really promising way of thinking about it. And then the third conclusion, and this is a slightly surprising one for me, I think we need the careful interaction between omnibus regimes and sector-specific regulation for this to work. And here I confess, I did come in with some preconceptions, perhaps partially driven by the horrors that Michael and I have discovered in our work on the EU AI Act, that omnibus regulation was not a good idea and had far more downsides to it than potential advantages. And there, I think our discussions today have really changed my mind, that actually there is a way in which we can potentially make the intersection between horizontal and vertical regimes work. Not in the way of the EU AI Act, certainly not in the way of regulating AI as a product, I should be very clear, but I think having certain transversal standards, I think, is a way of doing it, if we can get it right and we can get that interaction between the different standards right. Because if we get it wrong, and again, there you see the dangers of the AI Act, what we can't have is a sort of transversal regime then killing off various sector-specific approaches, whether it's long-standing approaches, the way Johanna has been telling us about co-determination in Germany, or whether it's very novel innovation. We heard from Daniel about the very recent innovation and approaches in Spain. So we can have those regimes, but we need to be very careful about how we actually design the interaction between them. And with that, I think the only thing left to do is to say thank you. Thank you to all of you participating, both online. I think we had just over 100 people at the start of the last session, which frankly, for it being 5 p.m. and all the troubles we've suffered with the tech is brilliant. Thank you to all of you who have actually come and joined us from really all over the world here in Oxford today. And thank you in particular also to all the panelists, both those sitting here right now and those over here. I think we had an amazing day of discussions, and really it's due to all of you really sticking to the brief we gave you. I think you really also very much addressed, and I think when we started first designing this, we were sort of thinking, okay, let's build together the stream list of people we want to have, and even if half of them turn up, we'll have a brilliant day. You've all turned up, and so we've had an absolutely amazing day. So a huge thank you, I think, from all of us to our panelists. And it's not just our panelists who made this day great, it's also the teams, both in terms of the AV supports and all the people here at Mansfield, in particular the Bonavera and the law faculty teams, Zoe, Sarah, Barrett, Sarah, and Tarkin. Thank you so much for all you've done to actually shepherd us through this day. And most importantly, a big thank you to Six, to Halifom, and to Ashlyn. I think I couldn't have done this without this team. It's been so much fun working with you, and really this conference is entirely your doing, and thank you so much for bringing us all together here. So then we agreed on the task. We've had plenty of inspiration on how to go about it. I'd say the race to regulate AI is on. Thank you.